3.
Judge Crown?
Yes.
Mr. Stewart is here with me as well, and as well as our own new CLI intern.
Okay, well, good morning to all of you. All right, we are live streaming on YouTube, and we've got several cases on the 9 o'clock docket. Ms. Hall, you're here on Eric Fry, 18 CT 1580. All right, and therefore?
Can we continue this next one?
To a plea date? All right. I created a new plea date yesterday. We have actually 2 options, but I can't remember what they are, so let me call Andrea. Andrea, can you remind me what the 2 different plea dates or plea dockets are? Remember, I created one yesterday. Okay. Both at 10. Okay, thank you very much. All right, bye-bye. Okay, Ms. Hall, I'll give you an option. We've got 2 different plea dates, January 25th at 10 o'clock or February the 8th at 10 o'clock. Ms. Santini, any objection to a plea on 2/8?
No objection.
All right, Eric Fry, 18 CT 1580 is continued to February the 8th at 10 o'clock for a plea. Also on the 9 o'clock docket, Ms. Hall has Samuel Ramos Carrillo, 20 CT 2199, and this is actually the state's motion for authorization to execute a subpoena. All right, so Ms. Santini, we're gonna have to move to 3-4 for the in custody folks today, and that includes this case, which we will do at the end of the docket, okay?
Okay, sounds good.
All right, so Ms. Hall, that's it for you for the 9 o'clock until we move over. All right. Ms. Santini, you've got another motion, the same thing, actually several. Do you know if these other folks are also in custody? Baum, Ellis May, Lozano, Rodriguez.
Doesn't appear.
All right, well, let's go to Baum, Guillermo Baum, BOHM, 20 CT 792. That's with Attorney Doyle. And I'll call him here in just a minute.
Good morning, this is Ryan Doyle.
Good morning, Mr. Doyle. This is Rob Crown calling. How are you today?
I'm doing well, Judge. Good morning.
I'm in court here with our prosecutor who's also appearing on the telephone. That's Ms. Santini. And we've got a motion to execute a subpoena for medical records in Guillermo Baum, 20 CT 792.
Yes, Judge.
All right. And Ms. Santini, you ready to proceed?
Yes, Your Honor.
Mr. Doyle, you ready to proceed?
I am, Judge.
All right. Now, your client's not here. Do you want to proceed in his absence?
I do, Judge. He's aware of the circumstances and aware of what the state is attempting to subpoena, and we are objecting to the motion.
Okay, so we can proceed in his absence.
Yes, Judge.
Ms. Santini, go ahead.
Your Honor, the state is asking the court to grant its motion to subpoena defendant's medical records. records are relevant to the ongoing investigation, and the state has to prove beyond a reasonable doubt that the defendant was running of alcohol to the point his normal faculties were impaired. The medical records are relevant to this investigation as they would reveal if alcohol was in the defendant's system, the level of alcohol present or drugs present, and any other signs of impairment. And in this case, LEO responded to a call in a public parking lot in reference to a man stumbling and struggling, looking intoxicated, attempting to find his vehicle. We have a witness providing a description of the car, license plate, and that the defendant had purchased 2 bottles of wine earlier in the morning from Publix. And once LEO observed defendant backing out of the parking space and stopped next to the rear of the defendant's vehicle. Both witnesses provided statements saying that the defendant bought the wine, and anyway, so the law enforcement observed defendant appearing to be confused, difficulty focusing, difficulty with hand-eye coordination, his thoughts. Defendant's speech was slurred, he had glassy eyes, and the odor of alcohol. There was also observation of a large bottle of Listerine, with 80% of it missing from the bottle. And law enforcement had defendant recite the alphabet, which defendant could not do so. And defendant admitted to buying the Listerine that day and drinking 80% of it prior to driving. And that bottle contained 21.6% of alcohol. And as such, Your Honor, the state is asking for you to grant our motion against the medical records.
All right, response, Mr. Doyle?
Judge, did the state provide any evidence to the court rather than just their proffer?
No, they did not.
Okay. My response to what they have just said is that under Hunter v. State, they are required to present evidence to the trial court to demonstrate that the confidential hospital records are relevant. And because they have not presented any evidence to the court, I would ask you to deny the motion upon that.
Don't you believe that I can take judicial notice of the booking sheet that's already been filed?
I think that's probably appropriate, Judge.
Well, let's go to Ms. Santini. Do you have a response to his legal argument?
Yes, Your Honor, we would just ask for the state to take judicial notice of the court file as a booking sheet is a part of that. And, Your Honor.
All right, well, I can't.
Understood, Judge. I understand the court. Sometimes I see where these reports are attached to the motion, and I don't believe that was the case here. My response is I have a little different a reading, and I don't agree with the reading that the state has just presented to the court. I'm looking at page 4 of the Collier County Sheriff's probable cause affidavit, and the pertinent part is, and I'm just going to recite it to the court.
Okay.
Due to COVID-19 concerns, Mr. Bohm was to be transported to the Naples Jail Center by prisoner van. While waiting for the transportation in the back of my patrol vehicle, Mr. Bohm complained of trouble breathing. Consequently, I requested EMS to the scene. While waiting for EMS, TO Corporal Ayers arrived in the prisoner transport van. Mr. Bohm was taken out of my patrol vehicle, at which time he stated he no longer needed EMS. However, he was unable to satisfy the jail's criteria regarding symptoms of COVID-19. Consequently, he was transported to the Naples Community Hospital North by Medic 48 paramedic Allen. Judge, the state has not shown a nexus, and they have not presented any evidence to prove or disprove the material facts based on Mr. Bohm's COVID medical clearance. He was taken to the hospital for the sole purpose of a COVID medical clearance. This was back in April when this event started, and they've had COVID-19 protocols. There is no compelling state interest for the state to have Mr. Bohm's COVID-19 medical clearance medical records. This is not the type of case where we see that sometimes there is an accident and a defendant is taken to a hospital, or while a defendant's at a hospital, medical personnel may tell law enforcement what their blood alcohol level is. We don't know even if there was a blood alcohol test done in this case. They're hoping that there is, and they're hoping that the court finds that a COVID-19 medical clearance, that there is a compelling state interest. But there is no relevance between COVID-19 medical clearance to then be just transported to the jail and a DUI investigation. There's no evidence in a COVID-19 medical clearance that tends to prove or disprove a material fact of a DUI investigation. So we are objecting to the issuance of the subpoena.
Okay, thank you, Mr. Doyle. That one paragraph on page 4, I read along as you were reciting it, certainly, or may appear to provide an alternative theory that you can use as a defense, but the balance of the booking sheet, I find, does establish the state's or satisfy the state's burden of proving that the requested information is relevant to an ongoing criminal investigation, including the allegations that the defendant had purchased 2 bottles of wine that morning from that particular Publix. He was observed stumbling and struggling in the parking lot and had the odor of alcohol. So over defense objection, the state's motion is granted. Now, the next question, Madam Clerk, is do we need a new court date, a pretrial for this case?
No, Judge, it's set for pretrial 13.
Already set, okay. All right, so Ms. Santini, I'll need an order from you regarding your motion, okay?
Yes, Your Honor. Is it okay if I just send an email with all of them at the end?
Of course, obviously copying Mr. Doyle.
Yes, Your Honor. Thank you.
Mr. Doyle, anything else from you?
Yes, it's my understanding that we have a pretrial conference set for tomorrow morning, Judge, by telephone. Is that something that we can handle today?
Sure. Would you rather cancel that and continue it to the next one?
I would, Judge.
Ms. Santini, do you have any objection to that?
One moment, Your Honor.
Calendar's correct set for tomorrow.
Yeah, I think you're right.
No objection, Your Honor.
All right. And Madam Clerk, I think that's February 17th.
Yes,
All right. So this case, the pretrial tomorrow is canceled, and we'll continue this pretrial to February 17th at 9 o'clock.
Thank you, Judge. Have a good day. Thank you, Ms. Santini.
You as well. Thank you, Mr. Doyle.
Excuse me.
Bye. Okay, next up is Mr. Fayette on Garrison Ellis May, 20 CT 2234.
Thanks for calling the Fayette firm. We look forward to speaking with you and discussing your...
All right, the next case is with Mr. Russo, and that's Renee Lozano, 20 CT 1968.
Hello, good morning.
Good morning, Mr. Russo. This is Rob Crown. How are you today?
Good, thank you.
We have our prosecutor, Ms. Santini, on the telephone as well, and we have a motion to execute a subpoena for medical records in Renee Lozano, 20 CT 1968. Mr. Russo, you ready to proceed on that motion?
Yeah, I thought, hold on, yes, I'm ready to proceed.
Do you need a minute?
No, I don't.
All right, Ms. Santini, you ready to go?
Your Honor, I believe this was stipulated to between Mr.
Yeah.
Russo and Marini.
No,
And there's a...
my hesitation there.
Okay. I don't see that. When you say stipulated, is there a written stipulation, or Mr. Russo, are you just here to say you do not contest it?
We do not contest it.
All right. Well, based on that representation, I'm sorry, Ms. Santini, what were you going to say?
I was just saying that there's already an order signed by you in the file.
Oh.
Petition.
So really, we just need to cancel the hearing.
Yes, Your Honor.
All right. Do we know whether this case is set for a pretrial?
For tomorrow, Judge.
Mr. Russo, the pretrial is set for tomorrow. Would you rather address that today and continue that a cycle?
Well, yeah, we can definitely address the pretrial, and what I would say is ready for trial.
All right. State, are you ready for trial?
One moment, Your Honor. Yes, Your Honor, we're ready for trial.
Well, does that mean you are foregoing the opportunity to issue that subpoena that I granted? Or are you ready to proceed?
We can get the records before trial.
All right, well, we're not setting trials right now. Both sides have announced ready for trial, so this is a court continuance, Mr. Russo, from tomorrow to the February 17th pretrial conference docket at 9 o'clock.
Thank you, Judge.
Mr. Russo, another question before I lose you here. You are also on the 10 o'clock plea docket for a plea in absentia.
Yes, sir.
Is that something we can do now?
Yes, sir.
Ms. Santini, how about you? Can you do that now?
I'm sorry, for what case?
Lopez, 20 CT 1880.
Yes, Your Honor.
See an absentia in the court file.
Madam Clerk, is that something you can do now? It's a no valid driver's license. Ms. Santini, are you checking, or did you say yes, you're ready?
Your Honor, the PIA looks good.
All right, and you agree to the terms in the plea in absentia?
Yes, Your Honor.
Mr. Russo, will you stipulate to venue in the factual basis contained in the discovery material?
Yes, sir.
All right, I will accept his plea. This is Gerardo Lopez, 20 CT 1880. I've reviewed the file and the plea in absentia. I'll accept his plea. This is a plea of no contest, find it freely, voluntarily, knowingly entered upon a factual basis and in his best interest. It's a withhold of adjudication, $250 fine, court cost of prosecution with 90 days to pay.
Thank you.
All right, thank you, Mr. Russo. Have a good
Okay.
day.
Thank you.
Thanks, bye-bye.
Oh, it's not there, Judge.
Will it be?
It will be.
Okay. Miss Santini, are you still waiting on your bar results?
Yes, Your Honor.
The reason I ask is Madam Clerk's having trouble finding your name. Mr. Stewart, would she put it under your name?
Yes, Judge, she's not going to be, the clerk won't be able to list her as an ASA. So yes, Madam Clerk can list me, but she's handling the docket as a CLI.
She's a CLI.
It doesn't matter.
Do you well just use
I have the names.
Well, she,
okay, so
what happens is the clerk will use my name or the ASA's name.
use Stewart's name.
Yes.
James Stewart. He's in there. Surely he's in there. Accept. All right, Mr. Vitale is next on the 9 o'clock docket with Vincent Rodriguez, 20 mm 1942. Are you Vincent Rodriguez? All right, I need to call your lawyer.
You have reached the law office of Nico Vitale. We are currently on the other line or away from our desk. Please leave a detailed message.
Miss Santini, I've got Vincent Rodriguez in the courtroom. You heard me just try to call Mr. Vitale without success. I will recall this and try to get him back on the phone here shortly, unless you tell me this is unopposed.
They have no position on this motion because it's up to the third parties that are listed in it. And of course, to you.
All right, anything else from you then, Miss Santini?
No, Your Honor.
All right, let's try to call Mr. Vitale one more time, see if we can get him.
Good morning, Your Honor.
Good morning, Mr. Vitale. How are you?
Fine, thank you. How are you, sir?
I am fine, thank you. We have Miss Santini for the state, also appearing telephonically for Vincent Rodriguez, 20 mm 1942. Your motion to issue a subpoena ducis tecum for surveillance video.
That is correct, Your Honor. There is the initial resisting act that led to Mr. Rodriguez's arrest occurred between Blue Martini and Cabo Lounge. My understanding is there's some surveillance cameras there. However, the security company that handles these matters for Mercado will not release anything without a subpoena, so that's why we're asking for one.
Okay, and I see on your certificate of service, you did include, in addition to the state, obviously, you included several different people. It looks like somebody from Bern, somebody from Blue Martini, somebody from Cabo Lounge.
That's correct, Your Honor. My understanding is that's who we needed to put on the certificate of service if they wish to lodge an objection.
But to your knowledge, based on your communication with them, they have no objection. They just require a court order.
That is correct. That is from, I did not contact Rocky Patel or Cabo Lounge because they referred me to the security company, but they do not have an objection to my knowledge.
All right, and Ms. Santini, the state has no position on the motion, right?
That's correct.
Okay, Mr. Vitale, your motion is granted. Will you send me a proposed order?
I will, Your Honor.
And do we need a court date for your case? The pretrial is tomorrow. I know that now you're going to...
You want to take care of it today, Judge?
Yes, let's roll this. The next pretrial would be February 17th at 9 o'clock.
Yes, sir.
You agree to that?
Yes, sir.
Ms. Santini, any objection to that?
No objection.
And Mr. Vitale, your client is here in the courtroom. Madam Clerk, are we printing notices? All right, so we're going to give him a notice so you don't have to come tomorrow. Your next court date is February 17th. That's a pretrial. You don't come that day either. Mr. Vitale will appear for you, okay? All right, so once you get that notice, you're free to go. All right. Thank you, Mr. Vitale. Oh, actually, I think I've got one more with you.
Yes, sir.
And that is Peter Sanguidolce, 19 MM 1695 for a plea.
Yes, sir. Mr. Sanguidolce has executed a plea in absentia that was negotiated with the state for one count of violation of injunction for protection against domestic violence. The proposed resolution would be a withhold of adjudication, a mental health evaluation, and follow recommendations. No contact with the victim, Marianne Sanguidolce, is soon to be former wife. No trespass at 4900 20th Place Southwest, which was the marital home. Paid court costs and costs of prosecution.
All right. Thank you. Ms. Santini, have you reviewed the plea and absentia paperwork?
Judge, I'm going to handle this one, but I'm familiar with the case. I have reviewed it. It is correct, and I would just add that, as I know you'll ask, is that I did speak with the victim. She is in agreement with the plea offer. The reason there is no batter's intervention program is due to Mr. Sanguidolce's current state of health, and the victim is okay with him not being on probation or having to deal with any of those counseling issues.
Okay.
Because statute does require batter's intervention, but the court can make written finding that it's not appropriate.
All right. Thank you. Based on that, we can proceed. Mr. Vitale, will you stipulate to venue and the factual basis contained in the discovery material?
Yes, Your Honor.
All right, I will accept his plea, find it freely, voluntarily, knowingly entered upon a factual basis and in his best interest. Withhold of adjudication. Well, there is no probation, right?
That's correct, Your Honor.
So how do we monitor the mental health evaluation and recommendations?
Judge,
I
that
don't-
was actually
I'm sorry.
supposed to be taken out of the plea in absentia.
Mr. Vitale?
I think
Judge, that is correct. I think what we did was I'm looking at a copy of the filed one. I will send we then after agreed to not have that in there. I had the original with that removed.
Okay.
Or, anyway, I have the original with that removed, but I did not file it yet.
Well, that's okay. I don't mind removing something. I'm sure your client would not object to that. It would be different if we were adding something. But Mr. Stewart, let me ask you, so mental health evaluation recommendations, that was part of your conversation with the alleged victim, and she agrees to delete that. And I think you said the basis was his current medical condition? She's okay.
correct. The victim is under the impression that the offer and the resolution is a withhold cost, no contact, no trespass.
All right, I will accept his plea, find it freely, voluntarily, knowingly entered upon a factual basis and in his best interest, withhold of adjudication, no contact with Marianne Sanguidolce, no trespass, 4900 20th Place Southwest in Naples, 34116, court costs, cost of prosecution, he would have 90 days to pay. All right, thank you, Mr. Vitale.
Have a good day.
You as well, thanks, bye-bye. Accept. All right, let's try Mr. Fayette again on the 9 o'clock docket, and that's for Garrison Alusme.
morning, Fayette Firm.
Good morning. Is Mr. Fayette there, please?
Yes, one moment, please.
Thank you.
The criminal justice system can be bewildering and frightening. At the Fayette Firm, we know that favorable results in a criminal case are obtained by legal skills and hard work. We'll work with you to look at all the options in the case and develop a strategy to get the best result possible in plea bargains, pre-trial motions, or trial. Whether misdemeanor or felonies, no case is too big or too small. The Fayette Firm has been helping clients in Florida for over 20 years. We're committed to giving you the most effective legal representation possible. Our address.
Judge Crown, he was doing Zoom court with traffic hearings.
Me to try back later?
Yeah, if you have another case, if you could call back, please, and then call me back.
Sure, will do.
Thank you so much.
Sure.
Bye.
Okay, bye-bye. Okay, so that's a recall, leaving us with one case on the 9 o'clock docket with Ms. Hall, and that is Samuel Ramos Carrillo, 20 CT 2199, who is in custody. So we need to move over to 3-4 for that. Do we know whether 3-4 is available? Okay. Okay. All right, very good. Thank you. 3-4 is occupied right now. Judge McPhee is in there. So we're going to wait on that as well. Obviously, we need to call Mr. Fayette back. Let's go to the 10 o'clock docket. Ms. Hall, I know you've got several cases there. Are there any that you can take early? All right, let me first ask Ms. Santini, are you able to proceed early on the 10 o'clock docket?
Yes, Your Honor.
Madam Clerk, how about you? Okay, Ms. Hall, who do you have?
I have Santa Inez Pulido Salas for case number 20 CT 1607 and 20 MM 128.
All right, thank you. Two cases with Pulido Salas. Good morning, ma'am. All right, Ms. Hall.
This is a she's going to be withdrawing her previously entered plea of not guilty and then entering a plea of no contest. The terms of which are for count 1, driving on suspended license and adjudication of guilt, 3 months probation that may early terminate. Can I have them read out, because I have 15 days and 10 days ago.
Sure. Ms. Santini, we've got two cases here. One is an MM, one is a CT. Can you tell me what the offer is, starting with the CT, 20 CT 1607?
Yes, Your Honor. So the state will announce the no cross in count 2 and 3 for week 2 count 1, which is adjudication of guilt, 50 days in jail, all costs, or there was the alternative of the adjudication of guilt, 3 months probation, may early terminate after completion of condition, 10 days jail, which may be done weekend work or weekend lockdown, as condition of probation, and all the costs.
Okay, so she's choosing the weekend work option. So the offer, to clarify, on count 1, driving on a suspended license, is an adjudication of guilt, court costs, cost prosecution, public defender costs, 3 months of probation, which may or shall? May terminate early upon successful completion of all terms, including 10 days in jail to be served on the weekend work program. Is that right? Okay, and then on the 20 MM 1282, that's a harvesting violation. What's the offer in that case, please?
And that would be a no cross in exchange for the police to 20 CT 1607.
No pros in exchange for the DWLSR. Ma'am, will you please raise your right hand, face the clerk to be sworn?
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
All right, you can put your hand down, ma'am. What is your name?
Santa Inez Pulido.
So you've got two cases. In 20 CT 1607, one of the charges is driving on a suspended license, and the offer on that charge is an adjudication of guilt, all costs, which include court costs, cost prosecution, public defender costs, 3 months of probation with the possibility of early termination once you're done with all of the conditions, which includes 10 days in jail to be served on the weekend work program. And once I accept your plea to that count, the state will drop the other counts and the other case. Do you understand all of that? Do you have any questions? Do you want to accept that offer?
Yes.
Are you pleading guilty or no contest?
No contest.
Did you read and sign this plea form? Do you understand everything that's explained on it? Do you understand that by entering your plea today, you are waiving all of those rights? Do you understand that your plea will be used against you in a deportation proceeding if you are not a United States citizen?
Yes.
Are you under the influence of drugs, alcohol, or medication? Driving on a suspended license is an enhanceable crime. If you commit this crime again, you may face higher fines, more jail time, and possibly a felony charge. You understand that? And the Department of Highway Safety Motor Vehicles may use your plea in this case against you for a future suspension of your driving privilege. Do you understand that? Ms. Santini, anything further from you by way of plea colloquy?
No, Your Honor.
Ms. Hall, will you stipulate to venue in the factual basis contained in the discovery material? All right, ma'am, I'll accept your plea to the DWLSR, find it freely, voluntarily, knowingly entered upon a factual basis and in your best interest, adjudication, judgment, and sentence as I previously stated. Ms. Santini, announcement on the remaining counts in 20 CT 1607.
Your Honor, state announced the no cross in counts 2 and 3 in 201607 and announcing no cross in case 20 MM 1282.
Okay, that's it, ma'am. Thank you very much and good luck to you. Madam Clerk. Yes? Did you need something? Accept. All right, thank you. I'm going to take these folks who are here early though. Are you ready? Miss Hall, who else? Joseph Colvin, 18 CT 28, excuse me, 2899. Well, I see a note here that says mandatory appearance. Yeah, I don't want him here if he's sick. Why would I have said mandatory appearance? Has he had a problem showing up in the past?
So I think 2 statuses ago, so he was in Alabama, because his parents, I think his dad died. And then last status, he was on his way. He told me he was on his way. But we waited for him to get on here, so I asked him today. And I spoke to him, and he said he was in town, he was just very late. He got here around 8.
Okay, Ms. Santini, so Ms. Hall, what's your request? This is Joseph Colvin, 18 CT 2899. He's not here for his plea. The request is a continuance to another plea docket. Ms. Santini.
Your Honor, it was hard to hear this call, but based on what we talked about at the BOP hearing on the 15th of December, you had said that you weren't going to have a PIA for this and you were requiring his appearance, and so the state is asking for a bench warrant. He's not present today.
My only hesitation is that he says he's sick. And considering the current circumstances, I'm inclined to give him that benefit of the doubt. We certainly don't want him to come in when he is sick. And so I'm not going to issue the bench warrant. I will continue the case to a plea docket I'll give him some more time. We'll go to February the 8th at 10 o'clock. If he's still sick, let him know this in advance. I need some sort of medical documentation regarding his health, or I will consider a bench warrant at the next docket, okay? All right. Any others for you at 10 o'clock?
Yes, one more. The other one's still waiting on.
Okay.
Francisco Diaz, 2016, 1842. This is also a PSA that I'm still waiting on.
We don't have the paperwork back? So this is Francisco Diaz, 20 CT 1842. Ms. Hall, your request is a continuance with a waiver? All right, Ms. Santini, the request is a continuance to the plea docket 2-8 at 10 o'clock. She's still waiting for the plea in absentia paperwork. All right, Madam Clerk, Francisco Diaz, 20 CT 1842 is continued to 2-8 at 10 o'clock. Ms. Hall, did you say that's it for you for now? All right, are you ready to go early? You have a 10 o'clock? You? Oh, I didn't recognize him. Okay, you're here with Mr. Casassa. Mr. Casassa, you're on the 10 o'clock. Do you want to go early? All right. Do you have a lawyer? That would expedite it. Are you waiting on somebody? Okay, so we'll wait for you. All right, Ms. Hall, I'm told that 3-4 is now available. Are you ready to move over for your 9 o'clock case to 3-4? All right, so we will be in recess, Ms. Santini, just for about 2 or 3 minutes, and then I'm going to call you back from 3-4, okay?
Okay, sounds good.
All right, bye.
is Nicole Santini.
Okay, Miss Santini, I am back in 3C. Ms. Hall is here for the Public Defender's Office. We have one case left on the 9 o'clock docket. And I'll try to call him again. And that's Mr. Fayette on Garrison LSM 20 CT 2234.
Good morning, Fayette Firm.
Good morning. Is Mr. Fayette available?
Yes, one moment, please.
Thank you.
The criminal justice system can be bewildering and frightening. At the Fayette Firm, we know that favorable results in a criminal case are obtained by legal skills and hard work. We'll work with you to look at all the options in the case and develop a strategy to get the best result possible in plea bargains, pre-trial motions, or trial.
Good morning, Judge.
Good morning, Mr. Fayette. How are you today?
I'm good. I'm sorry for all the trouble. I would think my old self is better at running from courtroom to courtroom than switching between Zoom and the phone.
Yeah, that's okay. No problem. We had other things to do, so it worked out fine. Our prosecutor is Miss Santini. She's appearing on the telephone. Your case is Garrison Alusme, 20 CT 2234. Mr. Fayette, are you ready to proceed on the state's motion to execute a subpoena for medical records?
Yes, sir. And I may be able to speed some things up. We'll see where the state's at, or if they're ready to go.
Miss Santini, you ready to proceed?
Yes, Your Honor.
All right, let's see. You piqued my interest with speeding things up, Mr. Fayette.
So, Judge, I don't have, as far as the state establishing a nexus to the medical records and the events that happened, I don't have an argument that's going to hold water for that. You know, for purposes of my representation, we object, but I can't give you a factual basis for that, Judge. So I think I fail my objection will ultimately fail. I think that they're going to be able to establish a nexus. My issue is a little more broad than that. I think that their motion's just a little too broad. They're asking for basically all of the medical records, and I don't know that they are entitled to all of the medical records. I think they need to narrow down what they're looking for.
Okay. Ms. Santini, do you have an argument on the scope of your request?
Your Honor, just because the standard is relevancy, any and all medical records that are relevant to the investigated charge are appropriate for the scope.
All right, Mr. Fayette, any other argument from you?
Judge, I think that they're simply entitled to any toxicology reports, any blood reports, as it relates to there. I don't see how it's relevant to have any of his other medical information disclosed there. This is to be a limited scope for the purpose of this criminal prosecution, and I don't know what else are they looking for besides a toxicology report or I guess there's not going to be any breath or anything there. What in the world else could they be looking for?
Do you have any authority to support your argument regarding the scope of the subpoena?
Other than the statute, Judge, as to how it's out, what's out there, if you want to, if you'll reserve ruling, if I can take a look at it and see, I've made this argument successfully in the past, but I don't know that I had any authority to it other than just the bare reading of the statute. If you'll give me just a little bit, and I can submit it to the, if I have something, I'll submit it to the court, to the state, and if I don't have anything, Judge, I'll let you know that, and you can roll on what you've heard.
I hate to take this under advisement. I've taken judicial notice of the booking sheet, and my finding is that the requested information is relevant to an ongoing criminal investigation. My inclination would be to grant the motion as is, and then Mr. Fayette, that way it's just not pending. And if you can find some authorities, if you can always file a motion for reconsideration, you'd want to do it fairly quickly before the subpoena gets executed.
That makes sense. That serves the same purpose, Judge, and then you close it out. That makes sense.
Okay, so the motion is granted. Ms. Santini, I'll ask you to send me an order. And the next question, Mr. Fayette, is I'm guessing this may be set tomorrow for pretrial. We may be able to, yeah, okay, you're on the pretrial conference docket tomorrow. Would you like to roll that to the next one?
Yeah, if we can, Judge, that'd be great.
All right, so Madam Clerk, this case will continue to the next private counsel pretrial. I believe that's February 17th at 9 o'clock. Okay, thank you, Mr. Fayette.
You said, I'm sorry, just cut out, February 17th?
Yeah, 2/17, yep.
Okay, great. Have a good day.
Thanks, you too. Bye-bye. Okay, that completes our 9 o'clock docket. We have several folks here in the courtroom. Mr. Kavanaugh is first on the docket with Ermal Adamaj, 2 cases, 20 CT 1847, 20 CT 1227. Good morning.
We also have a TR that was attached to that 20 TR 22699.
I do see that, yes, sir.
Okay. Regarding this case, Mr. Allen, I'd like to enter a plea of no contest to 3 charges, the 2 in particular, criminal traffic cases, is charged driving license suspended, and the officer that is accepted. Approved by the court would be that 20 CT 1227 will be adjudicated guilty, pay a $250 fine. He'll be on 6 months probation. As a condition of probation, we'll have 10 days of weekend work, and he'll pay court costs and costs of prosecution. This case would be concurrent to 20 CT 1847. That regarding that case, he'll be adjudicated guilty, $300 fine, 6 months probation, and 20 days of weekend work. Again, with appropriate costs, concurrent to 20 CT 1227.
All right, thank you. Ms. Santini, do you agree to those terms?
Yes, Your Honor.
All right, sir, will you please raise your right hand and face the clerk to be sworn? Thank you.
Swear or affirm that the testimony that you give shall be truthful and
All right, now you can put your hand down. What is your name? All right, Mr. Adamaj, you've got 2 cases again, 20 CT 1227. That's a driving on a suspended license charge. The offer is an adjudication of guilt, a $250 fine, court cost of prosecution, 6 months of probation, and 10 days in jail to be served on the weekend work program. Do you understand that offer? Any questions about it? In 20 CT 1847, it's the same charge, driving on a suspended license. The offer there is an adjudication of guilt, a $300 fine plus court costs, 6 months of probation, which will be concurrent with your other case, so that probationary period runs at the same time, and 20 days in jail to be served on the weekend work program. That's also concurrent with the 10 days, so you do it at the same time, and you get credit for all of the time you've already served. Do you understand that offer as well? Any questions about that case? Do you want to accept the offer in both cases? Are you pleading guilty or no contest? In both cases? Did you read and sign this plea form? Do you understand everything that's explained on the plea form? Do you understand that all of those rights apply to both cases? And do you understand that by entering your pleas today, you are waiving those rights? Do you understand your pleas will be used against you in a deportation proceeding if you are not a United States citizen? Are you under the influence of drugs, alcohol, or medication? Driving on a suspended license is an enhanceable crime. If you commit that crime again, you may face higher fines, more jail time, and possibly a felony charge. Do you understand that? And the Department of Highway Safety Motor Vehicles may use these cases against you for future suspension of your driving privilege. Do you understand that? And you still wish to accept the offers today? Yes? Yes. Mr. Kavanaugh, will you stipulate to venue in the factual basis contained in the discovery material in both cases?
Yes, Your Honor.
Ms. Santini, anything further from you by way of plea colloquy?
No, Your Honor.
All right, Mr. Adamaj, I will accept your pleas. Find them freely, voluntarily, knowingly entered upon a factual basis and in your best interest. Adjudication in both cases, judgment and sentence as I previously stated. Mr. Kavanaugh, in 20 CT 1847, as you said, you did consolidate a speeding infraction.
Yes, Your Honor.
Any request in that regard?
No, you just asked for consideration for.
I'll dismiss it based on the resolution in the criminal charges, okay? All right, thank you, sir. Can you scroll down for me? Accept. Okay, Mr. Brown. Relio Camacho, 20 CT 924. Yes, sir.
Your Honor, this is set for plea today. My office has sent a letter and it says we're, this is the second time we've set, unfortunately, last time before the time issue warrant was set. So all I can tell you is our mail's not reading, it's not being unreadable. My staff called him yesterday to try to reach him on the phone, did leave a message.
All right, Ms. Santini, did you hear that?
Not at all.
Okay, so this is Mr. Brown here for Aurelio Camacho, 20 CT 924. He's scheduled for an in-person plea. Mr. Brown is here, his client is not. Mr. Brown indicated that his office has made attempts to reach out and contact him unsuccessfully. So the state's request. There is a notice to appear in the court file for today's date, 1/12/21 at 10 o'clock. It's 10/11. And that, as you said, Mr. Brown, that was not returned.
State would ask for a bench warrant.
Mr. Brown, anything else from you?
There you go.
All right, this is a bench warrant, $2,000 bond. All right.
Hey, Your Honor, on your 11 o'clock,
Thank you.
Bill Alfonso, the state's motion to vote on. I can wait till 11. The only reason that I bring it up now is I have proof on my phone that I sent this to Mr. Green to file a motion. Mr. Alfonso's brought positive for going to testing. So we're up to 14 right now on his petition.
Okay.
And I'm sure that I was going to continue that.
Miss Ant.
State's made an offer that he's going to accept anyway, but
Okay.
I couldn't ask him to come today. I saw it. It was legitimate.
All right, Miss Santini, were you able to hear that?
No, Your Honor.
Philip Alfonso, 19 CT 1925 is your motion to revoke bond, which is actually set for 11 o'clock, but Mr. Brown just represented to the court that his client tested positive for COVID, and Mr. Brown did confirm that he saw the positive test result. And he also indicated that he plans to eventually accept the offer conveyed by your office. So his request is to continue the hearing on the motion to revoke bond.
Your Honor, the state, before I really look at my phone, I have a hard copy.
I accept your representation. He's seen it. It's on his phone. Any objection to the continuance?
A very brief continuance.
Well,
I don't know how long they told him to quarantine the test result. He received it January 4th, so that's already been 8 days.
well, let's see when my next.
A couple of weeks that they have to.
Yeah. Well, let's see when my next motion docket is, and then that may be fine. Madam Clerk, do you happen to know that, my next motion docket? February 16th. That's fine. So it'll be February 16th at 10 o'clock.
That sounds good. Well, that we hear that, Judge. I hope
Okay.
and get it worked out. Thank you very much for hearing that early.
Yes, sir.
Yeah.
Yes, the pretrial for tomorrow is canceled as well.
Oh, thank you. Yeah, I forgot that was my.
And let's reschedule the pretrial for 2/17. That's the day after the next motion docket, okay?
Right, and again, I expect it to be resolved after the motion hearing, so that will fall
Okay. 2 dates, yes ma'am. 2/16 for the motion docket and 2/17 for the pretrial docket.
off. Thanks, Ian. Sorry.
Okay, that's all right, thank you. Well, Mr. Gallops, I've got some other folks in front of you.
Okay.
Give me just a minute. I've got regional counsel on Timothy Charrington. I may have to call, but I do have Mr. Verderamo who's here on 2 cases. Zachary Couture. This is a petition to expunge. The case number is 20 MM 759. Ms. Santini, it does look like there is a certificate of eligibility in the court file indicating that Mr. Verderamo's client is eligible to expunge. What's the state's position, please?
I checked everything is there. I just wanted to check if he was paid to the clerk.
Well, that's good that you're concerned about that, but I want you to know that even if I were to sign the order, it would not be processed until that fee is paid. So
Okay.
eventually they'd have to pay it, but in any event, Mr. Verderamo says, yes, it's paid.
Okay, no objection, Your Honor.
That's all right. It won't be, yeah, if it's not in there, it won't be processed, so that's fine. Okay, so that is granted. And the second case with Mr. Verderamo is James Curry, 20 MM 1443.
That's a plea and he's in custody. So what we can do in today's plea will not affect his confinement status. He has 2 other felony cases pending. We can move this to another date where it can accommodate the court, where we can do it in person plea.
Okay.
Or it's easier for a 2A or 1C.
Okay.
If you're on bond. So
Well, I'll give you my next 2 plea dockets, and you tell me if I don't want to keep him in longer than necessary, but I've got January 25th and February the 8th,
either one's fine. I'm here. So
and he'll be in custody anyway.
he's in custody anyways on 2 other unrelated matters.
Okay.
So it's just whenever the courts, I guess, you're going to be in 2A or 1C.
Yep.
Or even 3-4.
Okay. Well, let's go to 2/8 then.
Or we can move it to this afternoon.
I can. 2:15.
Let's do that then.
All right. Ms. Santini, any objection to a plea for James Curry this afternoon at 2:15?
No objection.
All right. So ordered. 20 MM 1443 will add to the 2:15 docket.
I have a few others.
Yes.
Just call them.
Yep. Stanley Myrtle is 20 MM 918, also with Mr. Verderamo. Motion to modify conditions of probation.
There's 2 motions, Judge. There's a motion to modify condition of probation, and a motion to return to trial.
Yes, sir.
A motion to modify condition of probation as a condition of his sentence. Mr. Myrtle was ordered to have a GPS monitor. Mr. Myrtle resolved his case, pled no contest on September 23rd, 2020, was sentenced to 12 months of probation. Since release, there's been no violations of probation or violations of the GPS monitoring system. We're asking that it be removed into financial difficulty for the GPS monitor. As an aside, Mr. Myrtle is also on state probation, so he's not only supervised by county probation, he also has state probation, also checking in, so he's monitored by both entities. I'm sure the court that there's no violations or probation on this probation.
All right, Ms. Santini, your response to the motion to modify the condition of probation, specifically the GPS monitoring.
Yes, Your Honor. The state's position is that there's no legal basis for authority allowing this. The term ordered pursuant to a plea agreement, which the defendant entered, and there was no term within the agreement allowing the defendant to modify having the GPS. And unless it was agreed upon as part of the sentence that he can move the court at some point for removal of GPS, then the state's position is that the court would not have, unless it was agreed agreed upon, then the court would not have the authority to grant that motion. Essentially, that you, judge, will be changing the sentence. The defendant agreed to the GPS monitoring in exchange for the plea deal, and the only thing I found for law on this is the Florida Rules of Criminal Procedure, which allows the court to reduce or modify to include any provisions of a Chapter 948 Florida statute, a legal sentence imposed by it within 60 days after the imposition. And this is more than 60 days after September 23rd. And again, based on the argument that it wasn't even talked about in the plea agreement to modify the GPS conditions.
All right, so
Same with that.
Mr. Verderamo, she's citing 3800 rules which limit modifications to 60 days, I think, subsection C.
What I'll do is I'll contact Mr. Stewart because I don't believe it was contemplated, it wasn't on the record. I'll withdraw the motion. Or, I can't, off the top of my head, wasn't anticipating jurisdictional argument.
Well, do you want to address the motion to return property?
Sure. Judge, there were some firearms that were relinquished as part of the condition of his release on bond. He is on probation, state probation, as well as felony probation. He's not to possess any firearms. He's aware of that. However, the sheriff's office is holding those items. What we're asking you to do is a third party in custody of the firearms during the duration of probation. But the sheriff's office is not the custodian of the firearms. So that's merely what we're trying to do. So he would relinquish, he would not have possession of the firearms, but he would relinquish the ownership to someone else during his probationary period. So the sheriff's office is not holding on to it based on.
What's the difference to him?
It's my understanding that in the time period, he's going to be on probation for possibly another 2 years or so, and I don't know if the sheriff's office will do that.
All right, Ms. Santini, a response to this motion, please.
I don't know if
Your Honor, I'm not sure if there was a notice of hearing for that particular motion.
it was filed and a notice of hearing.
I'm looking at an amended notice which includes both motions. Did you hear the argument on the motion to return property?
Yes, Your Honor.
Additionally, the firearms were not utilized in the alleged offense, and they're merely the sheriff's office merely holding on to them at this point. I know there was a time period where the sheriff's office will notify an individual and say that they're going to destroy it.
Yeah. Well, so let me just address both motions. The motion to modify condition is denied without prejudice. I know you want an opportunity to do some further research or to converse with Mr. Stewart. So that's without prejudice. Motion to return property is likewise denied. As you said, I believe the sheriff's office will provide you and or your client with notice before they plan to do anything or dispose of that property. So you'll have an opportunity at that point to refile. So that's also denied without prejudice.
Okay, great.
All right.
I have one order I'll prepare another GPS denial.
All right. And thank you. Your next case is Juan Orozco, 20 mm 1124.
Judge, I'm going to ask for a continuance. This will be a resolution.
You say with a waiver
No waiver.
to a pretrial or another plea docket?
Another pre-trial. Or whatever sooner, whatever the first available.
Well, I've got a plea docket 125.
125 it is.
All right, Ms. Santini, any objection to that?
Are we setting it for a plea or a PTC?
A plea.
Okay, no objection, Your Honor.
All right, Juan Orozco, 20 mm 1124 is set on the plea docket January 25th at 10 o'clock. Let's make sure that we don't have any other court dates. You might also be on the pretrial docket for tomorrow? No. Okay, very good. Thank you. And your next case, Mr. Verderamo, is Adriel Rivero, 20 CT 848.
Was filed.
All right, Ms. Santini, have you reviewed the plea and abstention paperwork in this case?
Yes, Your Honor. The state's in agreement with the terms and the charges.
Mr. Verderamo, will you stipulate to venue and the factual basis contained in the discovery material? All right, this is a no valid driver's license. I've reviewed the court file as well as the plea in absentia paperwork. I will accept his plea, find it freely, voluntarily, knowingly entered upon a factual basis and in his best interest, withhold $100 fine, court cost of prosecution, and he will have 90 days to pay. Once we're done with the paperwork there, Mr. Bergeramo, we'll move on to your next case. Accept. All right, your next case, Mr. Verderamo, is Robert Sproul, 19 CT 926.
Mr. Sproul is in a hospital, and it has to continue to 25.
Ms. Santini, any objection to that?
No, Your Honor.
Considering how you began that with the hospital, would you prefer 2-8 or is 125 enough time?
Let's do 2-8.
All right, and that's also a plea docket at 10 o'clock.
Yes, that's great. 2-8 would be good.
All right, I just don't want to rush him if he's currently in the hospital.
I spoke to him yesterday. He did not sound good.
Okay, so we'll go to the second of the two dates for Robert Sproul, 19 CT 926, is set on the plea docket 2-8 at 10 o'clock.
Thank you, Judge. That's all I have.
All right, thank you, Mr. Berderamo. You as well. Okay, Mrs. Orange. Sorry, no, it's Mr. Gallops is next. He's left. Okay, Mrs. Orange, who do you have? You have Jose Ordonez Ambrosio, 20 CT 583. Good morning.
Your Honor, this was supposed to be a plea of absentia. I reviewed the plea of absentia and I realized that my assistant forgot to place her notary stamp when she signed.
Okay.
So I don't know if we could set this maybe later on this week.
I've got two different plea dates, 125 or 2-8.
Let's go with the 125. Maybe I can have some cover for that.
It's up to you. I don't want to create a conflict. I mean, if you want to go 2-8, that's okay too.
We can do 125, Your Honor.
That's at 10 o'clock, by the way. I don't know if that helps you with your conflict.
Sure, that's fine.
Okay, so Ms. Santini, the request for Ordonez Ambrosio is a plea on 125, 10 o'clock. Any objection?
No objection.
And that's 20 CT 583, so ordered.
Are you the 215 judge today?
All week, I am.
Is it possible for me to reach out to your office to see if we can get up?
Sure. If you can get that paperwork done.
Okay, we'll set it for 125 for now. In
Yep.
the meantime, I'll reach out to you.
Sure. Happy to take it early if you want to.
Okay, thank you.
All right. Mr. Gallops.
Judge, my client does not speak English. He is in the courthouse in a courtroom. Through a third party, she said she just got a message to him that he's in the wrong courtroom to go to DC. I'm waiting on my client,
Okay.
but he has been here.
All right. So just let me know when he shows up, and I'm happy to recall it. All right. Counsel, who do you have?
Good morning, Judge. Happy Tuesday. Attorney Gordon Kogler for Mr. Samuel Perez.
All right, Ms. Santini, let me just make sure our prosecutor can hear that. Ms. Santini, we've got Mr. Kogler here on Samuel Perez, 20 CT 1897, and his client is present as well. Good morning, gentlemen. All right, Mr. Kogler. No valid driver's license. All right, what's the offer, please?
Judge, this is a withhold adjudication, 1-year probation, no early term, 25 hours community service, 8 hours of traffic school. I'm not sure also, I didn't get a chance to go to the state record, there was a buyout option like with COVID. That would be the only caveat I'll be concerned about.
And court cost of prosecution.
Yes, Judge.
So the terms just articulated by Mr. Kogler, withhold, court cost prosecution, 12 hours of probation, no early term, 25 hours of community service, and an 8-hour driver improvement course. Ms. Santini, what do you say about that?
It was a 1-year probation.
Right, that's what we said.
Not 12 hours, but.
Judge, that calculation, that was a 1-year probation, no early term, 25 hours of community service, 8 hours of traffic school, and the only question I have for this state, if possible, is a buyout option, $10 per hour on 25 hours of community service.
What was that last part? I'm sorry. About the community
The question is whether he has a buyout option for the community service because of COVID. It may be hard to actually perform that.
That's fine. We can do buyout.
All right, give me just 1 minute. Sir, will you please raise your right hand and face the clerk to be sworn?
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
All right, you can put your hand down, sir. What is your name? All right, Mr. Perez, the charge again is driving without a valid license. The offer is a withhold of adjudication, so you will not be convicted. You will be placed on probation for 12 months with no early termination. All of the terms and conditions of your probation must be completed in the first 11 months. That includes paying court cost of prosecution, 8-hour driver improvement course, and 25 hours of community service. And you'll actually have an option on the community service. You can perform the community service hours. You can pay them off at the rate of $10 an hour at a location approved in advance by your probation officer, or any combination of the two. So you can perform some, pay some off. Do you understand all that? Any questions? All right, do you want to accept that offer? Are you pleading guilty or no contest? Did you read and sign a plea form? Do you understand all of the rights that are explained on that plea form? Do you understand that by entering your plea today, you are waiving all of those rights? Do you understand that your plea will be used against you in a deportation proceeding if you are not a United States citizen? Are you under the influence of drugs, alcohol, or medication? Mr. Kogler, will you stipulate to venue in the factual basis contained in the discovery material? Ms. Santini, anything further from you?
No, Your Honor.
All right, sir, I will accept your plea. Find it freely, voluntarily, knowingly entered upon a factual basis and in your best interest. Withhold of adjudication, judgment, and sentence as I previously stated. Thank you, Mr. Perez. Good luck to you. Thank you, Mr. Kogler. It's a second degree. All right, let me open this up again. Hold on. Yeah, that's true. So that would be 6 months. Miss Santini, what do you say about that?
I'm sorry, was that Your Honor?
Madam Clerk says this is a second degree misdemeanor.
Yes, Your Honor.
So we can't do 12 months. I totally missed that. Thank you, Madam Clerk. So that would be a maximum of 6 months of probation.
Your Honor, that's fine. We will agree to that.
Well, we don't have any choice. It's 6 months. Thank you, Madam Clerk. So ordered. Okay.
I apologize, Your Honor. My mistake.
So that means everything has to be done in the first 5 months. I told him he has 11. Make sure he understands 5. Okay, thank you. You as well. Thank you, Madam Clerk. Good catch. Okay, Miss Fish. Good morning.
Standing in for student Harmony. I have one case that is Pilot County. This is going to be a thing, and he
All right, so Ms. Santini, this is Kyle Downey, 20 CT 1105. Good morning, Mr. Downey. And this is a plea. Ms. Fish, what are the terms? Thank you.
And the first, well, the driving while under intoxicants, 0.15 or over, it's an adjudication of guilt, $1,000 fine, court costs, 12-month probation, no early term, can be mail-in. He is a finance student outside of the state of Florida, at school, 12 months driver's license suspension, DUI school, substance abuse evaluation, follow recommendations, random testing, 10 days vehicle impound, 15 hours of community service that may be bought out. We request that it be bought out. No alcohol clause. We were asking for a work exception because he works at an Italian restaurant when he goes to school. And the victim impact panel, a 6-month interval.
Okay, sir, will you raise your right hand, face the clerk to be sworn, please?
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
All right, what is your name?
Kyle Downey.
Okay, Mr. Downey, let me go over all of that again. There's a lot to it. I want to make sure you understand the offer. It's an adjudication of guilt, 12 months of probation with all of the following terms and conditions, which you must complete in the first 11 months of your probationary period. They include DUI school appropriate phase, substance abuse evaluation, follow recommendations, 1 victim impact panel, no possession or consumption of alcohol, no entering bars, taverns, saloons, pubs, or lounges, no alcohol in your residence, random testing at your expense, all costs, a fine of $1,000, a 1-year driver's license revocation, 50 hours of community service. There's a 10-day vehicle impoundment and a 6-month ignition interlock device. Now, there's no early termination on your probation, so you'll be on for a total of 12 months. Regarding the 50 hours of community service, you have to perform those community service hours, pay them off at $10 per hour, or any combination of the two. Now, your attorney asked for the ability to get a work permit or a hardship license through DMV. I don't have any objection to that, but just because I say no objection does not make it automatic. You still need to go to DHSMV and talk to them about doing that, okay? Any questions about that offer? Ms. Fish, anything else on the offer?
Well, the work exception, he works at an Italian restaurant, may need work.
When I said no entering bars, taverns, saloons, pubs, or lounges, that's with the exception of work. I still want you to go to work. I understand you may serve alcohol, you can't consume alcohol, and you need to leave when your shift is done. Anything else?
He said that he signed a lease with 2 other students, and he's worried that they might have alcohol.
So no alcohol in your room. Do you have your own room?
Yes, sir.
No alcohol in your room. Ms. Fish, anything else?
No, Your Honor.
Ms. Santini, anything from you?
No, Your Honor.
Mr. Downey, do you have any questions about that offer?
No, Your Honor.
Do you want to accept it?
I did.
Are you pleading guilty or no contest?
No contest.
Did you read and sign a plea form?
Yes, sir.
Do you understand everything that's explained on the plea form?
Yes, sir.
Do you understand that by entering your plea today, you are waiving all of those rights?
Yes, sir.
Do you understand that your plea will be used against you in a deportation proceeding if you are not a United States citizen?
Yes, sir.
Are you under the influence of drugs, alcohol, or medication? DUI is an enhanceable crime. If you commit this offense again, you may face higher fines, more jail time, possibly a felony charge. Do you understand that?
Yes, sir.
Ms. Fish, will you stipulate to venue and the factual basis contained in the discovery material? Ms. Santini, anything further from you?
No, Your Honor.
All right, give me just a minute to finish the booking sheet here.
Judge, I just have one question.
Yes, ma'am.
I thought I heard Ms. Fish say 15 hours of community service. Did you say that? Yeah. I thought it.
50.
50, it's 50.
50.
And this will be mail-in.
I have no objection to mail-in. You still have to check, you're gonna sign in with your probation officer here, but then I don't have any objection to mail-in. All right, sir, I'll accept your plea, find it freely, voluntarily, knowingly entered upon a factual basis and in your best interest. Adjudication, judgment, and sentence as I previously stated. Thank you, Mr. Downey, and good luck to you. Ms. Fish, we'll move on in just a minute, okay? We've got to finish the paperwork here.
Then we
yet approving anything.
Okay, thank you. And to be clear, where it says no alcohol in the residence, that is no alcohol in his room only. Just his room of the residence. Otherwise accepted. Thank you. Okay, Ms. Fish, who's next?
Nicholas Lamb, LAMM, 18CT2068.
All right, and she's standing in, Ms. Santini, she's standing in for Mr. Roy Stacker, Nicholas Lamb. Yes, ma'am.
And this is a plan of such that we did file. We have a copy here to sign. And this is our valid driver's license and failed registered motor vehicle. And this would be a no contest plate. And the terms are a withhold of adjudication, $150 fine, 50 cost of prosecution, and court costs to be determined.
Ms. Santini, have you reviewed the plea in absentia paperwork?
Yes, Your Honor, and we are in agreement with the charges and the terms.
All right, but did you tell me that we've got 2 counts, no valid DL and failure to register, and you just listed a plea offer for 1 count? And it says a withhold 150 plus costs. Is that the same for both counts? Are there 2 counts?
There are 2 counts, but the withhold and the fine are for both together. So 150 altogether.
Well, so we've got to pick one. So one of them will have a $150 fine and the other will not.
That's what I was, yes, Your Honor.
So the offer on the no valid DL is a withhold 150 plus costs to include court costs, cost of prosecution, 90 days to pay. And the offer on the failure to register is a withhold and composite cost, 90 days to pay. Ms. Fish, do you agree those are the terms?
Yes, Your Honor.
Ms. Santini, do you agree those are the terms?
Yes, Your Honor.
All right, are you in a position to stipulate to venue and the factual basis contained in the discovery material?
Yes, Your Honor.
And go ahead.
There were 2 tickets.
Right, there are 2 tickets. And do you stipulate?
Yes, Your Honor.
All right, I'll accept his plea, find it freely, voluntarily, knowingly entered upon a factual basis and in his best interest. No valid DL, withhold 150 in costs, registration is withhold and deposit costs.
You would ask the court to dismiss the 2 tickets.
We do have 2 non-criminal traffic citations that is granted, dismissed. Accept. All right, you're also covering for Mr. Roy Stacker on Brian Lubis, 20 CT 212.
Yes, Your Honor. He is approaching. This is a DUI third outside of 10 years and refusal to submit to test.
All right, good morning, Mr. Lubis. All right, thank you. Ms. Fish.
No contest, withdrawing, pleaded not guilty. Count 1, DUI third outside, 10 years adjudication of guilt, 12 months probation, no early termination, 15 days jail, credit for time served. As condition of probation, may be weekend work or weekend lockdown. 12 months driver's license suspension, DUI school, substance
adjudication of guilt, 6 months of probation concurrent, no early termination, 15 days jail with credit for time served as condition of probation, maybe we can work, we can lock down concurrent with other 15 days jail for DUI, 16 community service hours, may buy out, composite costs.
All right, Ms. Santini, do you agree with the terms?
Yes, Your Honor.
Sir, will you raise your right hand and face the clerk to be sworn?
Swear or affirm that the testimony that you
All right, you can put your hand down. Will you tell me your name? All right, let's go over the offer for the DUI first. It's an adjudication of guilt, 12 months of probation with no possibility of early termination, and all of the following terms and conditions which you must complete in the first 11 months. DUI school appropriate phase, substance abuse evaluation, follow recommendations, 1 victim impact panel, no possession or consumption of alcohol, no entering bars, taverns, saloons, pubs, or lounges, no alcohol in your residence, random testing at your expense, all costs, a fine of $3,500, a 1-year driver's license revocation, 2-year ignition interlock device, 10-day vehicle impoundment, and 15 days in jail with credit for the time served, the balance to be served on weekend work or weekend lockdown. Do you understand that offer?
Your Honor.
Yeah, hold on, Ms. Santini.
Yes, we can work.
Do you understand the offer? Ms. Santini?
I believe you said DUI first. I just want to clarify that it's DUI third outside.
That's my understanding. DUI third. If I said DUI first, I misspoke. All right, count 2 is refusal. The offer is an adjudication, composite costs, 6 months of probation concurrent with your 12 months for the DUI, no early termination, 16 community service hours, which you must perform or pay off at the rate of $10 an hour, or any combination of the two, and 15 days in jail concurrent with count 1, credit for time served, weekend work, weekend lockdown. Do you understand that offer? Any questions about the offer? All right, do you want to accept the offer?
Yes, sir.
Are you pleading guilty or no contest?
No contest.
Did you read and sign a plea form?
Yes, I did.
Do you understand everything that's explained on the plea form? Do you understand that by entering your plea today, you are waiving all of those rights? Do you understand that your plea will be used against you in a deportation proceeding if you are not a United States citizen? Are you under the influence of drugs, alcohol, or medication? Ms. Fish, will you stipulate to venue and the factual basis contained in the discovery material? DUI is an enhanceable crime. If you commit this crime again, you may face higher fines, more jail time, and possibly a felony charge. Do you understand that? But you understand that. Ms. Santini, do you have anything further by way of plea colloquy?
No, Your Honor.
All right, give me just a minute to finish reading the booking sheet. All right, sir, I'll accept your plea, find it freely, voluntarily, knowingly entered upon a factual basis and in your best interest. Adjudication on both counts, judgment and sentence as I previously stated. Thank you, sir, and good luck to you.
All right, thanks, sir.
Yes.
Appreciate you guys.
I would ask to remove this federal suspended without knowledge. We consolidated that.
Granted.
Thank you.
All right. You're free to go. Thank you, sir. All right, give me just 1 second here. We'll move on. Madam Clerk, I'm curious about the monetary section at the top. The PD fee is, you've got that listed as $3,500. That's actually the fine. The fine is $3,500. PD fee would be 50. And there's a 2-year ignition interlock. Yeah, for the DUI. Am I missing that? I don't see it. We also need a victim impact panel. Oh, okay. Well, you tell me when you're done. Accept. Okay, your next case, Miss Fish, is Jonathan Miller, 20 CT 1287. All right.
A driver while license suspended, revoked with knowledge, to be entered a plea of no contest, withdrawing a plea of not guilty, and it is an adjudication of guilt, $150 fine, 6 months probation, day early term after 3 months, 8-hour driver improvement course, court costs, and costs of prosecution.
Sir, will you raise your right hand, face the clerk to be sworn?
Do you swear or affirm that the testimony that
Thank you.
give shall be the truth, the whole truth, and nothing but the truth?
All right, you can put your hand down. Miss Santini, do you agree with those terms?
Yes, Your Honor.
All right, sir, what is your name? All right, this is a driving on a suspended license charge. The offer, again, is an adjudication of guilt, $150 fine, court costs, cost of prosecution, 6 months of probation, with the 8-hour driver improvement course. Now, you have to get everything done within the first 5 months of your probation at the latest, although you do have the possibility of terminating probation after 3 months if you're done by then. Do you understand the offer? Any questions? Do you want to accept the offer? Are you pleading guilty or no contest? Did you read and sign a plea form? Do you understand everything that's explained on the plea form? Do you understand that by entering your plea today, you are waiving all of those rights? Do you understand that your plea will be used against you in a deportation proceeding if you are not a United States citizen? Are you under the influence of drugs, alcohol, or medication? Driving on a suspended license is an enhanceable crime. If you commit this crime again, then you may face higher fines, more jail time, and possibly a felony charge. Do you understand that? Ms. Sorry? All right. Now, Ms. Fish, will you stipulate to venue in the factual basis contained in the discovery material?
Yes, Your Honor.
All right, sir, I'll accept your plea. Find it freely, voluntarily, knowingly entered upon a factual basis and in your best interest, adjudication, judgment, and sentence as I previously stated. Thank you, Mr. Miller, and good luck to you, sir. Yes. I don't have any objection to either one. Thank you. That's it for you? Yes. Okay, thank you, Ms. Fish. Accept. Okay, Mr. Gallups has Eduardo Domingo Garcia, 20 CT 2065. Okay, Mr. Gallups, what are we doing? All right, what's the offer?
Withhold $150 for cost of prosecution. She does not speak English. I reviewed the form with him in the presence of the interpreter.
Ms. Santini, do you agree with the terms?
Yes, Your Honor.
Sir, will you raise your right hand and face the clerk to be sworn?
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth? Yes.
All right, you can put your hand down. Sir, what is your name?
Eduardo Antonio Domingo Garcia.
The offer is a withhold of adjudication, $150 fine, plus court costs and costs of prosecution, and you have 90 days to pay. Do you understand that? Do you have any questions? Do you want to accept that offer? Are you pleading guilty or no contest? Did you?
We discussed a no contest plea outside.
All right, we'll show that as a no contest plea. And Mr. Garcia, did you review a plea form with your attorney?
Yes.
Do you understand everything that's explained on that form?
Yes.
Do you understand that by entering your plea today, you are waiving all of those rights?
Yes.
you understand that your plea will be used against you in a deportation proceeding if you are not a United States citizen?
Comprende que si no es ciudadano estadounidense, esta declaratoria será usada en su contra en una audiencia de deportación. Yes.
Are you under the influence of drugs, alcohol, or medication?
¿Se encuentra bajo la influencia de drogas, alcohol o medicamentos? No.
Mr. Gallops, will you stipulate to venue in the factual basis contained in the discovery material? Sir, I'll accept your plea.
Acepto su declaratoria.
Find it freely, voluntarily, knowingly entered
Encuentro que ha sido hecha libre, voluntariamente y con conocimiento de causa.
upon a factual basis and in your best interest.
Existe motivo fundado y lo que más me conviene.
Withhold 150 and costs.
Su culpabilidad no consta, 150 de multa y costas procesales.
Thank you, sir, and good luck to you.
Gracias, señor, y buena suerte.
And thank you, Mr. Gallops.
While I have the interpreter here, if you want to pay something today, take the paperwork.
Accept.
First floor.
Si quiere pagar algo hoy, puede llevarse sus papeles y paga en el primer piso. Okay, I want to
Okay.
thank you.
Very good. Thank you, sir.
Gracias.
Yes, sir. Madam Clerk, you good? All right, Mr. Clark is here on Timothy Charrington, 20 MM 901. Good morning. Good morning, sir. Will you please raise your right hand, face clerk to be sworn?
Swear or affirm that testimony that you give shall be the truth,
Okay, you can put your hand down, Mr. Clark.
Your Honor, Mr. Chairman, is going to withdraw his previous application. I'm holding a police co-contact to the two charges, two counts of discharge. First being criminal mischief, and second being petty theft. Terms for the criminal mischief judge are going to be a withhold of adjudication, 6 months of probation, which may be early terminated after 4 months. That will run concurrent with the probation allowance in count 2. There's going to be an anger management class, 16 hours of community service. Now, there was restitution to be paid by Naples Bay Resort. I'm not sure if the state has come up with an actual number for that yet.
Ms. Santini, did you hear the question?
We have not been able to get in contact with the victim.
Okay.
Very well, Judge. So for purposes of that, we would ask that you order and reserve restitution for the gate, the Naples Bay Resort, but we would like to put a time limit on that.
State? The request is that I order restitution reserve on the amount for 90 days.
That's fine, Your Honor.
Okay.
And then there's also going to be a no trespass at that particular location, Naples Bay Resort. I don't know if the state has the address of all
I have the address according to the booking sheet. 1500 Fifth Avenue South in Naples, 34102. 1500 Fifth Avenue South, Naples, 34102. Ms. Santini, is that the address you want the no trespass order for? You look into that, Mr. Clark, go ahead.
Court costs, cost of prosecution, we would ask for counsel fees. Judge, on count 2, petty theft, it's going to be a withhold of adjudication, 6 months of probation, which may be early terminated after 4 months, or concurrent with probation. Count 1, the ACF milepost class. Again, it looks as though there's restitution to Naples Bay for the cart involved in this case. I'm assuming they don't have that amount either, so our request will be duplicated for that, order on reserve for 90 days for them to get the cost of the cart. If the cart was returned, Judge, just the question is when it comes to damages. And then there will be composite costs.
All right, Ms. Santini, do you agree with the offer? Were you able to?
I'm just checking that the address is transferred to.
Well, you can keep checking on that. If you agree with the offer, I'll start the plea colloquy while you're checking.
Yes, Your Honor.
You agree with the other terms? Okay. Sir, have you been sworn in? He's been sworn. All right. Tell me your name, please. All right, Mr. Charrington, again, on count one, criminal mischief, it's a withhold of adjudication. All costs, which include court costs, costs of prosecution, there's also costs for regional counsel. 6 months of probation. You have to get everything done in the first 5 months of probation, although Mr. Clark did negotiate the possibility of termination after 4 months if you're done by then. The conditions include no trespass at the address I previously indicated, which is the Naples Bay Resort. Anger management, I want you to sign up for that within 30 days of today's date. 16 hours of community service, and I'll order restitution reserve on the amount for 90 days. Count two is petty theft. The offer there is a withhold. Composite costs, so again, court costs, cost prosecution, regional counsel costs. 6 months of probation, which is concurrent with count one, so it runs at the same time. It's not in addition to. Get everything done within the first 5 months with possibility of early term after 4. ACF milepost class, again, just like the anger management, I want you to sign up for that within 30 days of today's date. And I'm ordering restitution, reserving on the amount for 90 days. Ms. Santini, have you confirmed the address?
Yes, Your Honor, I was at 1500 Fifth Avenue.
Okay. Sir, do you have any questions about the offer? Do you want to accept it? Are you pleading guilty or no contest? Did you read and sign a plea form? Do you understand everything that's explained on the plea form? Do you understand that by entering your plea today, you are waiving all of those rights? Do you understand that your plea will be used against you in a deportation proceeding if you are not a United States citizen? Are you under the influence of drugs, alcohol, or medication? All right, theft is an enhanceable crime. If you commit that again, you may face higher fines, more jail time, possibly a felony charge. Do you understand that? Mr. Clark, will you stipulate to venue in the factual basis contained in the discovery material?
Yes, sir.
Ms. Santini, anything further from you by way of plea colloquy?
No, Your Honor.
All right, sir, I'll accept your plea to both counts. Find your plea freely, voluntarily, knowingly entered upon a factual basis and in your best interest. It's a withhold of adjudication on both counts, judgment and sentence as I previously stated. Thank you, Mr. Charrington, and good luck to you, sir.
Thank you very much, John.
Thank you, Mr. Clark. Thank you. Accept. Okay, counsel, good morning.
Morning, Your Honor. Ryan Dugan on behalf of the CONSEQUENTIAL Law Group, Your Honor, for Eric 1420MM936. We're here to enter a plea today.
All right, good morning to you and to Mr. Warmkey. Ms. Santini, do you see this case?
Yes, Your Honor.
All right, 20MM958. Yes, sir.
936, Your Honor.
The court says, file here says 20MM958.
And I was given the wrong information from my Mr. Camedeco, I'm sorry, 958, Your Honor.
Yes, sir, but let me look at the information actually here, the charging document. And we'll go by that. And it does say 20MM958 with Eric Warmkey.
I apologize for that, Your Honor.
That's okay.
Your Honor, at this time, Mr. Warmke would like to withdraw his previously entered plea of not guilty and a plea of no contest. The agreement with the state is a withhold of adjudication, a $250 fine, court cost, and cost of prosecution. He has reviewed and signed the plea form, Your Honor.
I'm curious, when I see the nature of the charge, why are we not including a no trespass? Ms. Santini, can you address that, please?
Yes, Your Honor, one moment.
Okay. Thank you.
Your Honor, if the defense has no objection, we'll add the no trespass to the offer.
Well, if they do have an objection, I won't take the plea. I would require it. I would require a no trespass at the Target Superstore. So, Mr. Wormkey, first of all, I want you to raise your right hand, face the clerk to be sworn, and I'll ask you some questions.
Swear or affirm that testimony that you give shall be the truth, the whole truth, and nothing but the truth.
Okay, you can put your hand down now. Tell me your name. So the offer that your attorney just represented was a withhold of adjudication, $250 fine plus costs. I would also include a no trespass at the target where this allegedly occurred. Do you understand that additional requirement? It means you can't go back there. But it also means you don't have to accept the plea offer. I'm adding something that you didn't know about. If you don't want to accept the offer, you don't have to. Do you understand that? Do you need any time to speak with your attorney about the additional requirement? Or anything at all? Do you still want to accept the offer? All right, are you pleading guilty or no contest? Did you read and sign a plea form? Do you understand everything that's explained on the plea form? Do you understand that by entering your plea today, you're waiving all of those rights? Are you under the influence of drugs, alcohol, or medication? Counsel, will you stipulate to venue and the factual basis contained in the discovery material?
I will, Your Honor.
All right, and Ms. Santini, based on your review of the allegations in this case, you believe the offer articulated with the additional requirement of no trespass is appropriate?
Yes, Your Honor.
All right, sir, I'll accept your plea. Find it freely, voluntarily, knowingly entered upon a factual basis and in your best interest. Withhold $250 fine, court costs, cost of prosecution, and no trespass at the Target Superstore located at 2415 Tarpon Bay Boulevard in Naples. Thank you, sir, and good luck to you.
Thank you, Your
All
Honor.
right.
Gentlemen, when I have my issues.
Yes, sir. Thank you.
Your Honor.
Okay. Do you want me to repeat it? Yeah. And accept. Mr. Casassa, you have an evidentiary motion, correct?
That's correct.
All right, thank you. All right, next up, Ms. Santini, I'm going to call Mr. Schneider on Ingrid Davila Human, 20, well, that can't be right. CF, no, 20 mm 169. Was this the felony reduction? 20 mm 169. Okay, let's call Mr. Schneider. Thank you.
Law office.
Good morning, Mr. Schneider. This is Rob Crown. How are you today?
I'm okay, Judge. Good morning.
We have our prosecutor, Ms. Santini, is also on the telephone for your case, Ingrid Human, which is 20 mm 169.
Correct.
What would you like to do this morning?
Well, last 3 or 4 times we were here, Judge, I had no ability to contact her. She was deported back to Guatemala, which is why I think you said it for this morning.
Okay. So no one is coming forward. I guess she's not here. There is a notice to appear in the court file for today's date, 1/12/21 at 10 o'clock. It's 11:13. Mr. Schneider, would you like me to proceed?
I don't have any legal basis to argue against that, Judge.
All right, State, what's your request, please?
The state would request a bench warrant for $4,000.
Bench warrant, $4,000 bond. Thank you, Mr. Schneider.
Have a good day.
You as well, thanks. Bye-bye. Next, I'm calling attorney Milrod on Jean Noel, 19 CT 2779.
Traffic ticket guy.
Good morning. Is Mr. Milrot there, please?
May I ask who's calling?
Yes, this is Judge Crown calling in Naples.
Hold on. Judge who?
Crown?
Brown?
Crown, C-R-O-W-N.
Sorry, thank you. Hold on.
Thank you.
Thank you for calling the law offices of Mark Milrot and the traffic ticket guy. We'll be with you in just a moment. Defending your traffic ticket isn't our only business.
Good morning, Judge. How are you?
I'm all right. How are you, Mr. Milrot?
We're doing.
I'm in court this morning with our prosecutor, Miss Santini. She's also on the telephone. Your case is Jean Sergo Noel, 19 CT 2779.
Correct, and I know we've requested multiple continuances. We're having a difficult time communicating with Mr. Noel in responsiveness and language. So I'm hoping we have another translator and we can just resolve the case shortly.
What type of translator does he need?
English is his language, but just some of the questions, I just want to make sure that he understands fully and completely of resolving and what the ramifications are to him.
Well, where is he?
He's local in Deerfield Beach, or at least local to us on this side.
Well, are we here? We're here for a plea today. He's not in court. How did you plan to proceed without him? I don't see plea in absentia paperwork in the file.
No, we had we're having him fingerprinted, and unfortunately we haven't had that accomplished.
Oh, so you plan to enter a plea in absentia? You need more time for the paperwork. Is that what you're saying?
It is, correct.
Are you requesting a continuance to another plea docket with a waiver?
We are.
Ms. Santini, any objection?
No objection, but we would ask for the defendant's presence to be required at the next court date.
Well, I'm not going to do that yet. So I will grant the request. Madam Clerk will continue Jean Noel, 19 CT 2779 to the plea docket February the 8th at 10 o'clock, and that will be for a plea in absentia.
Understood, and we will have our paperwork. Thank you, Judge.
All right, thank you, Mr. Milrot. Have a good day.
You too.
All right, bye. Next is Attorney Rondon on Jesus Vargas Pera, 20 CT 1428. This is for absentia. Hello, is this Attorney Rondon?
This is Judge Crown.
Yes, good morning. How are you?
Good morning. How are you doing?
I am fine, thank you. Our prosecutor is Miss Santini. She's also appearing telephonically. Your client is Jesus Raymond Vargas Pera, 20 CT 1428, and I believe we're here to accept a plea in absentia.
Yes, that's correct.
All right, Miss Santini, have you reviewed the plea in absentia paperwork?
Yes, Your Honor, the state's in agreement with the terms and the charges.
All right, Mr. Rondon, will you stipulate to venue and the factual basis contained in the discovery material?
Yes, I will.
All right, I've reviewed the court file as well as the plea in absentia paperwork. I will accept his plea, find it freely, voluntarily, knowingly entered upon a factual basis and in his best interest, and this is to the charge of driving without a valid driver's license. The sentence is a withhold of adjudication, $150 fine, court costs, and costs of prosecution, and he's got 90 days to pay. Mr. Rondon, anything else on that case?
There'll be nothing further, Judge.
All right, thank you. Have a good day.
Thank you. You too.
Thanks. Bye-bye.
Bye-bye.
Is Mr. Moffett here? No. Ms. Santini, what's your understanding? Have you been in touch with Mr. Moffett on Piccoli?
No, Your Honor.
All right, I'm going to call him next.
Morning, Your Honor.
Good morning, Mr. Moffett. How are you today?
Fine, sir, and you?
I am fine, thank you. We're here on Joseph Piccoli, 20 CT 476. I've got the prosecutor as Ms. Santini on the telephone. Ms. Santini, this is your motion to revoke bond. Are you ready to proceed?
Yes, Your Honor.
Mr. Moffett, are you ready to proceed?
Yes, Your Honor.
All right, Ms. Santini, go ahead.
The defendant in this case, in May 3rd, 2020, the defendant was cited for driving on suspended license in the county, and when he was cited for that, he was out on bond for the Collier case, 20 476, the DUI charge, and right now he is in Lee. He was bench warranted in Lee on September 15th, and so we are asking for the motion for vote bond to be granted in 20 476, and we're asking for an arrest warrant if he's not present.
He is not present. All right, thank you. Mr. Moffett, your response, please.
Judge, if you're asking for a warrant, I would just ask for a moderate bond. It's driving on a suspended license from out of state. He's on the pretrial conference docket tomorrow. As you might have some notes in the file that Mr. Piccoli is not in the United States. And I believe you had required him to appear tomorrow, either in person or by telephone or by Zoom, whatever the court's preference would be. But I don't anticipate him being there tomorrow. My same request would be on a bench warrant tomorrow, just that a moderate bond be set.
All right, I'm taking judicial notice of the court file and specifically the first appearance court order, which I signed. I was actually the presiding judge at his first appearance on the instant charge, and I signed this on March 2nd, 2020. That was for a DUI. I also take judicial notice of the exhibit attached to the motion to revoke bond.
Your Honor, if I may.
Sure.
I just wanted to clarify that the state is asking for the arrest warrant to take him into custody today.
No, Your Honor, what we're asking for is the court granting our motion and the order would be signed that says order revoking bond and to take him into custody, and that order would act as a warrant. So we're not asking for a bond amount.
I understand that. You want him held no bond.
Yes, Your Honor.
And I'm taking judicial notice of the motion and the exhibit attached to the motion, which has a date of where did I see that? Hold on. It looks like you've attached the traffic crash report from our case, the DUI, on May 3rd. I thought you had attached something. Your basis for your motion is that he was arrested in Lee County while out on bond in the instant case. Do you have any exhibits that you've attached to show that?
There should be the citation.
Oh, was it on the same? Was it on the same day? I do see a citation in here on 5/3.
Yes, Your Honor.
I do see that from Lee County. All right, based on that, the state's motion is granted, and Ms. Santini, I'll need you to submit the warrant, please.
Yes, Your Honor, will do.
Okay, Mr. Moffett, do you want to wait and see if we have him for trial or for the pretrial tomorrow?
Judge, I have a number of other cases on your docket tomorrow. And the off chance that he might miraculously appear, perhaps you could address it tomorrow morning.
Sure, we'll just leave it as set then.
Thank you, Judge. I don't have anything else on your docket.
Ms. Crane, go
Tomorrow,
ahead.
the state's gonna ask the court, if he doesn't appear, we're just gonna ask the court to mark that case as inactive because there's an active warrant for him.
I understand. We'll address that tomorrow at pretrial. Okay, thank you. Thank you, Mr. Moffitt.
Thank you, Judge.
All right.
Have a great day.
You too, bye. Talbot Fuller. We have two cases with Ms. Hall, 18 mm 2376, 19 CT 717.
Yes, Your Honor. I tried calling this morning. Wasn't able to reach him. But as soon as he asked me to back on the VOP.
Back on the VOP date. State?
I'm sorry, I couldn't hear, Ms. Hall.
He's not here, and she's asking that we put him on a VOP hearing docket. Oh, he's in custody. So what were we going to do today? But but are they pleas? Are they hearings? So do you want to add him to the 215 docket? All right, Ms. Santini, we've got two cases with Mr. Fuller. We'll add both to our 215 docket this afternoon, 18 mm 2376 and 19 CT 717. Okay, next you have Fernando Guzman Cruz, 20 CT 1399. All right, I'm reviewing the file for notice. This is again Fernando Guzman Cruz. There is a notice to appear in the court file for today's date, 1/12/21 at 10. It's 11/26, and he's not here. Request from the state.
We would request the bench warrant. And we would request a pickup order.
Date of birth 04. He's still got to be on. Okay, so this would be a pickup order and a release to his parents. Madam Clerk, you need a minute on that? Can you guys tell if he's in the detention center already? All right, we'll come back to this one. Mustafa Hamrouni, 19 mm 2158, Ms. Hall.
Yes, Your Honor. We didn't put this on here because I was unsure whether I'm going to be or for trial. I believe it's leading to trial, so
Are you already? It sounds like you've been in touch with him.
Yes, Your Honor.
All right. Are you already on a pretrial docket, maybe for Thursday? No, you're not. All right, so the request is a continuance to a pretrial conference docket with a waiver. Ms. Santini, do you have any objection to that?
We would request a bench warrant since it's not present today, and it's just 2019.
Ms. Hall?
I believe I want to go to trial, Your Honor.
Right, but were we set for a plea today?
I told you at the last pretrial docket that I wasn't sure if we wanted to plea or go to trial, but we're still discussing, and you said we'll have to
Okay. All right, so we will continue this, Madam Clerk, to the next PD pretrial, which may be 218? 218 at 9 o'clock. Thank you. All right, so Fernando Guzman Cruz, thank you. 20 CT 1399. He's the juvenile who is not in custody, so that is a pickup order and a release to his parents. And Ms. Hall's last case is Christina Rosentrager, 20 CT 891. Okay, good morning, ma'am. And what would you like to do, Ms. Hall? the waiver? Any objection?
Your Honor, the updated offer that the state sent to Ms. Hall was at her request. I mean, if the defendant's there, let's resolve the case.
Well, yeah, that would be great, but she wants to check into the effect it will have on her driving record with DHSMV. I think that's a valid request. And so the request to, or the motion to continue with a waiver is granted. We'll set this on, you want to go to a plea docket, 125 or 28? 28 at 10 o'clock, ma'am. You'll get a notice. Once you get your notice over here, you're free to go. We'll see you then. Thank you. Oh, okay. Yes, that's it for you. Yes, thank you. All right, see you then. Jeffrey Stone, 20 MS 308. This is the state's motion to issue a subpoena for medical records. Jeffrey Stone, are you here? Not here. On an 11 o'clock. State, do you believe we have Stone to address?
I'm sorry, what was that, Your Honor?
Do you believe that we still have Stone to address?
Oh, yes, Your Honor.
Okay. All right, Jeffrey Stone is not here. There is a notice of hearing in the court file indicating today's date, January 12th at 11 o'clock. It's 11:31, and he's not here. Ms. Santini, go ahead.
So the state is asking court to grant its motion to subpoena defendant's medical records from Collier EMS and SCH downtown from the date of November 20th.
All right.
And the relevancy standard is just that the medical records are relevant to the investigation. I'm sorry, that's the date is November 6th. And the defendant was charged with DUI damage, being investigated with DUI damage, and he was taken to SCH downtown and he exhibited signs of impairment. So we're just asking the court to grant a state motion.
All right, and I'm taking judicial notice of the report you attached to the incident motion. Indicates that this was a crash. He was the driver of one of the vehicles, had difficulty exiting the vehicle, may have been driving on the center of the road. He indicated, he actually stated that he may have cocaine and oxycodone in his system. Based on my judicial notice of the report attached to your motion, I find that the requested information is relevant to an ongoing criminal investigation, and your motion to subpoena the medical records is granted. And Ms. Santini, I'll ask you to send in an order, please. Okay, Mr. Casassa is next. Madam Clerk will start that when everybody's ready. The last case on the docket, Mr. Casassa, is John Garreau, 19 CT 1514.
Your Honor, we're going to come to the courtroom if that's okay.
Come on down.
And Your Honor, is it okay if we have the CLI intern as well?
Sure. 3C.
Okay, thank you.
Okay. Doesn't matter to me. You're here first, you pick. Absolutely. We're going to be in recess until they get here. No, I'm going to stay right here. Okay. So does it help you if I mean, I don't. Yeah.
No. So I just want to know.
I have to stay right Yes, sir.
Yes, but I don't see it on your docket.
2018-42. Is that a CT?
Yes.
20 CT 1842 Francisco Diaz. No valid driver's license. It does say proceeding plea. Oh, well, defendant not here. Oh, did he come forward when he called his name? No. Oh. Well, we just lost our public defender, so we need her to come back down. Can you try to get a hold of Ms. Hall? Do you know how to do that? He was, I can tell you that when we called this case this morning and he did not come up, it was continued to 2/8 at 10 o'clock. So we're either going to leave that, or if we can get Ms. Hall back in here, then we can address it today. But in the meantime, once everybody gets here, I've got to proceed with Mr. Casassa. Madam Clerk, how about you? Are you good to go? All right, thank you. We are back in session. We do have a motion to suppress in John Garreau, 19 CT 1514. Mr. Casassa is here. Mr. Casassa, are you ready to proceed on your motion to suppress?
I am, Judge. I would ask that the roll be voted.
If you are a witness in this case, you have to wait in the hallway until we call your name. While you're there, do not discuss the facts of the case. State, are you ready to proceed on the motion to suppress? All right, Mr. Casassa, this is your motion. Do you have anything by way of opening statement you want to make?
Judge, first I ask the court to take judicial notice of the profile. I would ask the court to note in the sheet that this was a search. And I would submit to the court that this should work with the statement.
All right, let's see. So who is arguing? Who should I refer to? Ms. Santini. Well, first of all, I want to get your response, if any, to Mr. Casassa's request. He just asked me to take judicial notice of the court file, specifically the fact that this was a warrantless search and arrest, right, Mr. Casassa?
The arrest, yes, that's correct.
And because it's warrantless, it would then shift the burden of proof to you to establish the validity of the search. Do you agree to that? All right, I do as well, and I do take judicial notice of the court file for that purpose. So now you have the burden of proving the validity of the search. And so, Mr. Casassa, anything else by way of opening statement, or was that?
I think the motion is self-explanatory.
All right, and I have read the motion. This is about the search into, I'm not sure if it was his home or a home.
It was his home, Judge. Law enforcement entered his position, and it was a violation.
All right, thank you. And Ms. Santini, I didn't mean to cut you off. Do you have anything by way of an opening statement you want to make? You're just ready to call your first witness? All right, go ahead.
The state would like to call Ashley Litter. Ashley Litter.
Yeah, Madam Clerk.
Swear or affirm that testimony that you give shall be truthful and nothing but the truth.
Morning, ma'am. Before we go any further, Ms. Santini, let me just ask Mr. Casassa, just for the record, I notice your client is not here. You're choosing to proceed in his absence.
Judge, yeah, with your permission, I filed a waiver.
All right, I just wanted to make sure that that was your intention. Okay, Ms. Santini, go ahead.
Good afternoon, Ms. Whalen. Will you please state your name and spell your last name for the record?
Ashley Elizabeth Whalen, W-A-Y-L-A.
Thank you. And going back to June 26th of 2019, a while ago now, do you recall what you were doing around the evening?
Yes, I was driving.
Judge, I'm sorry, obviously with mass, I'm having a little trouble hearing, so maybe we can cover.
If you could speak up just a little bit. And if that still doesn't work, Mr. Casassa, you're free to move up a little bit closer, sit in the jury box if you need to.
Yes, I was driving.
And that night while you were driving, did you observe anything out of the ordinary?
As I was driving, yes, as I was driving down 41, there was a further approach, driving around.
And when you say erratically, what do you mean by that?
As I was driving down 41, he was turning on 41 on the side street and I pulled past the stop sign very quickly and almost keep on the car. And I didn't have to see there was damage to the front end of the vehicle.
And after that happened, what did you do next?
I started
Sorry, I didn't understand the last thing. You saw him stumbling around, and then what did you say?
I said I wasn't really sure.
Okay, thank you.
I'm sorry, I didn't hear that either.
She said, I'm sorry, go ahead.
I said I wasn't really sure he was kind of stumbling around.
Okay, I thought you said something after stumbling around.
I wasn't really sure he was kind of.
Okay, thank you, sorry.
And at that point, what did you do? At that point, I parked my car, started watching him, and observed him walking across the street, then walking across the field, and going up to the apartment and trying to get into the apartment. And when he was at the apartment, did you observe anything like that? When he was at the apartment, he was at the door and was trying to get inside. He kept dropping his keys, and it took him probably 5 minutes just to get to the front door open. And at any point, did you call 911? Yes. When did you make that call? Honestly, I don't recall at what particular moment. It was whenever I was generally concerned for what was going to happen. And why did you, going back to when you started calling him, why did you begin to call him? I started calling him because I felt like he had just committed a crime. Like I said, I was driving down 41, and I saw how he was driving and how the front end of the car was totally damaged. It looked to me like he had just left the scene of the accident. And did law enforcement arrive at some point after that? Yes. And did you tell law enforcement everything you just told us? Yes. And then you did fill out the sworn statement that night? Yes. And when law enforcement arrived, did you identify to them the apartment door that you saw that it knocked? Yes, I identified the door and also him as well. And going back, you said you saw him struggling at the door. Did he ever enter through the door? He kind of saw it go. And again, just to clarify, you did identify, or I'm sorry, the defendant wasn't outside, law enforcement was there. When law enforcement came, was the defendant outside? Yeah. No further questions.
Okay, don't go anywhere though, Ms. Santini, because I have a question. I'll give you a chance to follow up, and then Mr. Casassa, of course, for cross. I'm curious, you said you identified for law enforcement the exact apartment door and him. How were you able to identify him? He's inside the apartment door closed. How did you identify him to the law enforcement officers?
Because I watched him get out of his car that he was driving, or the car that he was driving, and walk across the street, walk across the field, and walk up to the apartment, and let himself inside.
I'm not questioning your opportunity to view him and see him, but how did you identify him? In my mind, it sounds like you identified him before they went in. Or are you saying, did you wait around until they brought him out and said, yeah, that's the guy? How did you identify the person?
So at the end of everything, after I called the cops, they originally let me leave the scene. The officer called me back, asked me to do a statement. Whenever I returned to do the statement, whenever they had him outside, and I identified him.
Okay, so that's what you meant when they first arrived, you identified the apartment door, then you left, and then you came back, he was outside, and that's how you identified him. Got it, thank you. Any follow-up to those questions? All right, Cross?
We have a question.
Yes, sir.
Morning, Ms. Whalen. I appreciate your patience this morning. You didn't see that automobile get into an accident, did you? Have you ever seen that automobile before? And had you ever met this gentleman before? Have you ever seen him to your knowledge? And when law enforcement came, was this a house or an apartment?
It wasn't like an apartment, like a two-story apartment building. It was not a house. It was, a couple of units on like one floor level.
There was a fence around it, correct? Around the back?
I do not recall a fence. I did not walk or see one.
So there could have been a fence you just didn't see. Is that possible?
Possibly.
I'm sorry?
Possibly.
Okay. Now, when law enforcement came, you gave them a description of this individual, correct?
Yes.
You pointed out the automobile, is that correct? And you told them that you thought this gentleman was intoxicated.
Yes.
You never said that he was injured, did you? Matter of fact, you specifically didn't tell him he was injured because you thought he was intoxicated, correct?
I told him I thought he was intoxicated.
I showed you a picture of the automobile, would you recognize it? I'm sorry?
Quite possibly. I remember it by New York license.
I'm going to show you what has been marked as Defense Composite Exhibit 6. May I approach, Judge?
Yes, sir.
Oh, I'm sorry, you gave it to me. No, you're almost. Again, I'm showing you Defense Composite Exhibit 6. Would you take a moment to look at those pictures, please? Does that appear to be the automobile that you saw? And again, you didn't see that automobile until it crossed your path and you followed it into this residence, correct? Now, you indicated you didn't know Mr. Giroux and you've probably never seen him before, is that correct? So you'll agree with me that you don't know the way he normally is and the way he normally walks, correct? I have no further questions for this judge.
Ms. Santini, any redirect? Is Ms. Whalen free to go? Mr. Casassa, you agree?
I agree, Judge.
Ma'am, thank you very much for your patience this morning and your testimony. I appreciate it. You're free to go. Have a great day. Thank you. All right, Ms. Santini, next witness, please.
State license call, started by Deputy Ashby, Sergeant Ashby.
Shall be the truth, the whole truth, and nothing but the truth.
Morning, Sergeant. How are you? All right, thank you.
Good afternoon. Can you please state your name and spell your last name for the record?
Natalie Ashley, last name is A-S-H-B-Y.
And how many years, or I'm sorry, what is your occupation?
I'm a sergeant at the Clark County Sheriff's Office.
And how many years have you been working for CSO?
Just over 6.
And what is your, what are your duties right now?
Right now, I'm the diversity coordinator for the agency.
And going back to June 26th of 2019, were you on duty that night?
Yes, ma'am.
And do you recall why, or sorry, were you dispatched to a scene that night?
Yes, ma'am.
And you recall why you were dispatched to the scene?
They crashed it.
And when you arrived on scene, did you speak with any witnesses?
Yes, ma'am.
And who is that?
Ashley Wayland.
And what did Ms. Whalen describe to you of her observations?
She observed a vehicle driving rapidly on T-bone her. She followed that vehicle because she thought that it had been in a crash. She witnessed the driver of the vehicle and the vehicle stumbling, and she said that he appeared to be either intoxicated or injured.
And did she say anything about going to his apartment?
Yes, ma'am.
And what did she describe to you about that?
She stated that she followed him through a field to his front door where he struggled to gain entry and went into the residence.
And can you briefly just explain the layout of this place, of the field and the apartment, the field where the defendant had parked his car?
to the north of the residence, in front of a tree.
Was it a far distance?
No, ma'am.
About how many yards did you say?
I don't know exactly.
Did his position of the vehicle seem out of the ordinary?
Yes, ma'am.
Why is that?
It was under a tree.
And did Ms. Whalen describe to you anything about the defendant's car?
That the front end was damaged.
And did you relay this information to the other officers that came on the scene?
Yes.
And did Ms. Whalen point out the door that the defendant entered into you all?
Yes, ma'am.
And at that time, after hearing all of this information from Ms. Whalen, did you reasonably believe that the defendant could have had a medical emergency?
Judge, I'm gonna object to closer reading.
Overruled.
Yes, ma'am.
And why do you think that? So why do you think that you had reasonable belief that the defendant could have had a medical emergency that night?
Because the vehicle had been in a significant crash.
Anything else?
And the description of the witness of the defendant walking out of the vehicle, that point appeared.
And also, did the witness describe to you when the defendant did out the door of his apartment?
She advised that he was struggling to get into the apartment.
Did that also go into your reasonable belief?
Yes.
And as a result of believing that the defendant could have had a medical emergency, what did you all do on the scene afterwards?
What did we do immediately?
Let me rephrase that for you, I'm sorry. When the other officers arrived on the scene, did you tell them this information that you received from Ms. Wayland?
Yes, ma'am.
And after that, what did you all decide to do?
We called for EMS to stand by.
And why did you call? I'm sorry.
And fire.
And why did you call EMS and fire?
Because we believe that he could be injured.
And what happened after that?
EMS and fire arrived on scene. Entry was made in the rear of the residence.
And before entry was made, did you all attempt to knock on the door?
Yes, ma'am.
Where did you knock?
Front door, the windows. There's no answer.
How many windows did you knock on?
Several.
Was there a back door?
There was a back door.
And were you knocking loudly?
Yes, ma'am.
Did you announce your presence?
Yes, ma'am.
Was that loud as well?
Yes, ma'am.
And was there any answer?
No, ma'am.
And did you hear any noise inside?
No, ma'am.
And at this point, did you have even more concern about the defendant?
Yes, ma'am.
And is that because of no response after knocking and announcing your presence? And so at that point, what did you do?
Entry was made in the rear of the residence.
Thank you. No further questions.
All right. Cross?
Zachary, were you present when Ms. Whalen filled out a sworn statement? Were you the one that took the sworn statement?
I do not believe so.
Okay, first witness, Judge.
You may.
The show is marked as offensive to one page document. You recognize that?
Yes, sir.
That's Ms. Whalen's sworn statement, correct?
Yes, sir. Yes,
And she gave that at the scene and filled it out, correct?
yes, sir.
Okay. And she told you when
when she first reported what she saw, that she pretty much wrote that into the statement, correct?
What she stated, what is written into the statement, yes, sir.
Okay. And in fact, Miss Ashby, excuse me, Miss Whalen never told you that my client was injured. Is that correct?
I can't recall that. It's in my statement, so I'm sure she did.
Well, I know what you put in your statement, but that's not what Miss Whalen told you, correct?
I cannot verbatim remember exactly that day. It was 2 years ago.
Okay. Well, as a matter of fact, if you look at this statement, nowhere in that statement does Miss Whalen say that Mr. Giroux was in fact injured, correct? Or she thought he was injured.
She may have stated it to me, not written it in her statement.
Okay. That statement says she believed, she was of the opinion he was intoxicated, correct?
Your Honor, objection and irrelevance. This is irrelevant to the motion.
Overruled. The question is what the statement says. She thought he was intoxicated.
Correct.
That was the question. Is that what the statement says?
It doesn't.
Okay.
And nowhere in that statement does it say that she thought he was injured. Take a minute.
No, sir.
I'm gonna show you what's been marked as defense exhibit, composite exhibit 6. Recognize the automobile depicted in those pictures.
Yes, sir.
Okay. Is that the automobile you saw when you responded to the scene where Mr. Giroux was ultimately arrested?
Yes, sir.
Does that picture substantially depict the way, the condition of Mr. Giroux's vehicle at the time you saw it and before he was arrested?
Yes, sir.
Had you ever seen that car before that day?
No, sir.
So you don't know what kind of damage might have been done to that car beforehand?
No, sir.
All you know is that there was some damage to that car.
Yes, sir.
And you were told that the car had in fact driven to that location, correct?
Yes, sir.
Now, you indicated that you had knocked on the door of that house and the windows, correct?
Yes, sir.
But you didn't hear anything inside.
No, sir.
You heard nothing inside to indicate that someone might be needing help or injured or was asking for help.
No.
And you indicated that you ultimately accessed the house or the apartment or whatever it was, correct?
Yes.
In order to do that, law enforcement went through a gate that had a lock on it, correct?
No, actually, fire did.
Okay, well, but you went through that gate.
Yes, after.
They had to take the gate off the hinges, correct? Off the pins.
I'm not sure.
Okay. And let's talk about how you got into the actual residence. There was a sliding glass door, correct?
Yes.
And they took that off the tracks, correct?
I believe so. I'm not sure how they did it.
Okay, that door was locked, correct?
I am not sure.
And that gate, and I already asked, the gate was locked before you went in, correct?
I am not sure.
So you never tried that gate before?
I did not go to the residence and not to the front of the windows, to the front side.
But ultimately, law enforcement had access to the entire perimeter of that house, correct?
Ultimately, yes.
And before you entered that house, you didn't see Mr. Giroux.
Yes.
And other than Miss Whalen, no one saw Mr. Giroux that you could speak of.
Correct.
Did you ever see the automobile that Mr. Giroux initially hit?
No, sir.
Okay, one more time.
Yes, sir.
You remember I took your deposition
Yes, sir.
on November 9th of last year?
I believe that was the day.
Okay, and that was in front of court reporter.
Yes.
And you were sworn to tell the truth.
Yes, sir.
And you knew why you were there, correct?
Yes, sir.
And we were talking about this very sequence of events, correct?
Not in this much detail, but yes.
Do you remember when I asked you during that deposition, did you tell someone that the witness, Ms. Whalen, said that Mr. Giroux was injured?
Yes.
Remember that question? And you said, yes, I did.
Yes.
And then I said, okay. And you then said, or no, not injured, stumbling. Do you remember saying that?
It's possible, yeah. it's recorded because I did.
Okay, so you didn't say, you said not injured, stumbling, correct?
Yes.
I have no further questions, Mr. Judge.
All right, any redirect, Ms. Santini? All right, and is Sergeant Ashby released? Mr. Casassa, do you agree?
I would be there.
All right, thank you, Sergeant. You're free to go. Have a great day. All right, Ms. Santini, next witness, please.
The state trial witness is Sergeant Cohen.
You swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
I swear.
That's me, Sergeant.
Good afternoon, Sergeant Cohen. Can you please state your name and spell your last name for the record?
My name is Sergeant Brian Cohen, ID 2194, last name is C-O-H-E-N.
Thank you. And what is your occupation?
I'm a deputy sheriff with the Pike County Sheriff's Office.
And how many years have you been working with CCSO?
Starting my 18th year.
And going back to June of 2019, what was your duty or what was your position or what was your title at that point?
I was a sergeant in the North Naples District.
Okay. And on the night of June 26, 2019, were you on duty that night?
Yes, I was.
And were you called or dispatched to a scene of anything?
I wasn't actually dispatched, but I did respond to the scene.
And do you know what the call was in reference to?
There were actually several calls for this. There was, I believe, 3 calls for service. 2 were vehicle accidents, one of them being a hit and run, and the third was somebody who followed the vehicle who was providing updates.
And did you respond to 1135 Shady Rest Lake that night?
Where I actually responded to is I came in off of Solana to an apartment complex that is just south of that address.
Okay, thank you. And what was your duty on scene that night?
I was the shift supervisor, basically overseeing the incident.
And that evening, did you speak with Miss Ashley Whalen?
I did not.
Did any of the other officers that night tell you what Miss Ashley Whalen had described to them?
When I got on scene, I made contact with now Sergeant Ashby, who relayed information to me.
And what did Sergeant Ashby describe to you about what Miss Whalen had observed?
She said that another person described our subject stumbling out of a car, involved in crash, and entered an apartment and pointed at an apartment door. She described that she was knocking on the door, got no responses from the occupant inside.
And do you recall Sergeant Ashby detailing to you anything about the defendant's driving?
I knew from information from the radio and as well as the CAD information, the computer automated dispatch, that there was a hit and run crash with substantial frontal damage, as well as a possible vehicle versus a tree, a secondary crash involving the same vehicle. Plus with the information that I had with Sergeant Ashby, that was the information that I gave.
And you mentioned that Sergeant Ashby described to you the defendant stumbled. Did she mention to you the defendant breaching his apartment or an apartment?
mentioned that the subject was followed from the car to a specific door. Sergeant Aspey pointed out the door to me that he's in that apartment, and they were trying to make contact with the person inside, and there was no response from them.
And so, were you not one of the ones that knocked on the doors and the windows?
I also knocked on the doors. I walked around the unit itself as best as I could. Part of the unit was obstructed by a white PVC privacy fence, but I knocked on the front door, down sheriff's office, was yelling out, "Are you okay?" All that information. I knocked on all the windows that I could. One of the windows was later determined to be the actual bedroom where he was, Mr. Trumper.
And going back to before you even started knocking on the door, why did you decide to knock on the door to make contact with the defendant?
Based on the information that I had from the CAD, there were 2 vehicle crashes, as well as the behaviors described by the person stumbling out of the car, getting to the house, the way they were not answering. I believe that there was somebody that was injured inside the apartment. They were no longer capable of responding to us.
And so at that point, before knocking on the door, did you have reasonable belief that the defendant could have had a medical emergency?
Absolutely.
And again, you mentioned that Sergeant Ashby pointed out the door to where the defendant was described to enter. You knew exactly which door that was?
Yes.
And then after, as you told us, that you knocked on the doors and windows, was that very loud knocking?
Yes. I mean, it was a loud pounding. It was behind the mask. Obviously, you can hear I have a booming voice, but when I yell, you can hear it. It's clear.
And did you try several times with the knocking and announcing your presence?
Correct.
And did you hear any response?
There was no response within.
And did you hear any noise from within?
No noise.
And at that point, did you have even more concern about the defendant inside?
Yes, because we were blocked up with the area with the PVC fence. I requested full fire to assist us with the fence and an EMS to stand by.
And why did you call it EMS?
Because again, we're there for the medical emergency for this person. That I believe there's a medical issue inside.
Okay. And at that point, was it your call to enter into the residence?
Yes, it was my decision.
And again, why is that? Why did you decide that?
Well, obviously, there's a number of factors of when a law enforcement officer can enter a residence. Among them, obviously, consent, search warrant, or arrest warrant, and that's their address. But also, there's the exigency. And with this one, with there being 6 exigencies listed out,
I sustain the objection. Don't phrase it in terms of I don't want you to explain the law to us.
Sure.
Just explain. I think her question is what led you to believe there was a medical emergency or exigency that caused you to enter the residence. Just give us the factors.
Understood. Again, with the factors of the vehicle crash, hit and run, significant front end damage. Another vehicle accident that was called in where the vehicle was believed to hit a tree, as well as the behaviors exhibited by the driver getting out of the car and leading to the door that we were in. I believe that the person was injured from the accident, especially since there's no response from all the attempts to contact them.
Thank you. No further questions.
All right. Cross.
Mr. Cohen, you said you were the shift supervisor?
Yes, sir.
Does that mean that you basically take charge and review reports and make sure everything is accurate and complete?
That's part of my duties, yes.
And I'm sure what's been labeled as Defense Exhibit 7. Do you recognize these pictures, sir?
They were a Range Rover. This was the vehicle crash accident was done by a different officer.
Yep.
And I'm not in charge of that person.
Okay, you're saying you never viewed that vehicle?
I've never saw that vehicle. No.
Okay, but that vehicle doesn't have any significant damage, does it?
I've never seen that vehicle. These are just 3 pictures. The back end are also black and white, not a full perspective. But
And in fact, the accident report in this case lists that damage to that vehicle is minor, correct?
I don't have that accident report. Again, nor did I.
I thought you reviewed reports to approve.
Not every report from every single deputy that I was able to sit here. No.
Okay, so you didn't review this accident report, is that what you're saying?
Correct.
Now, you didn't
see the crash.
No, sir.
And you never spoke with Miss Ashley Whalen.
No, sir.
So Miss Whalen said that Mr. Giroux was intoxicated and not injured. You would have no way of knowing that.
I would have no way of knowing, especially if it's intoxicated, because people believe that some people are intoxicated.
Well, I'm going to check this
Okay, sustained. Repeat your question. And then Sergeant just answered his question.
Sure.
Ms. Santini will have a chance to ask you some more questions if she chooses to.
Well, let's go back.
Yeah.
You didn't see Mr. Giroux before you breached the fence.
Correct.
And the fence was locked.
Correct.
And then you went to a sliding glass door, correct?
Correct.
And that was locked.
Correct.
You took it off the hinges, or you took it off the track.
No, we didn't take it off the track.
What'd you do?
It was actually just a slight lift to lift it over the lip of the locking mechanism,
Okay.
and the door slid.
Okay. But it was essentially, it was intended to be locked and you guys opened it.
Correct.
Okay. And then you went into the residence.
Correct.
And that was the first time you saw Mr. Giroux.
Eventually, we made contact with him within the residence.
Okay. Now, how long have you been in law enforcement?
It'd be 19 years. That includes my own.
You've been to residences before, correct?
Yes, sir.
And you've been to residences where you were looking to find someone, correct?
Yes.
And you've been to residences where you're looking to arrest someone, correct?
Yes.
And people don't always open the door, do they?
No, they don't.
They don't always respond when they know it's law enforcement.
Correct.
Particularly if they might have committed some kind of crime, right?
Correct.
So the fact that someone didn't answer the door or answer the window or make noise inside, that doesn't necessarily mean they were injured, does it?
No, but coupled as a totality, I believe they were in.
May I put you in this judge?
Yes, sir.
I'm going to show you what's been marked as defense deposit exhibit 6. You recognize that?
That's the vehicle that was by the church.
Okay. That's the vehicle that was at the scene. It was suspected to be in the crash with the Range Rover, correct?
Later determined, yes.
Okay. Now, would it surprise you to know that Ashley Whalen never said anything about that vehicle hitting a tree?
There was a CAD comment for the vehicle versus a tree, yes. There was a call this.
That doesn't mean hit the tree, it could be against a tree or under a tree.
I can only go with the facts that I was having at the time.
Okay, again, you never spoke with Ashley Whalen.
No, sir.
And Ashley Whalen was the witness who saw Mr. Giroux and pointed out the residence.
Correct, I believe. I spoke with Natalie Ashby when I got out.
Okay, one moment, Judge.
Yes, sir.
The information you got about Mr. Giroux, you got that through Natalie Ashby.
Correct.
And then there was another deputy there, correct?
Well, now Sergeant Kitchener.
Yes. She's outside, right?
Yes, sir.
Did she fill you in as well?
The information I got was from Sergeant Ashby.
So it was secondhand information, actually.
From Sergeant Ashby?
Yes.
From fellow officer, correct.
Well, from the fellow officer and from Ms. Whalen.
I never spoke to Ms. Whalen.
I know, Ms. Whalen said things to Ashby. Ashby told you.
I can only testify to what the information I received from Sergeant Ashby.
And again, I'm phrasing that as secondhand information.
From a fellow deputy?
Well, no. Ms. Whalen told Ms. Ashby. Ms. Ashby told you.
Again, I can only testify to what Sergeant Ashby has relayed to me.
I don't have any further questions to this witness, Judge.
Any redirect? All right.
When you were knocking on the door and the windows, was it your intent at the time to arrest the defendant?
No.
And what was your intent when you entered into the residence?
To check on his welfare. Considering the information that I have, that there was two
I'm asking you, Judge.
Overruled. Go ahead, you can answer.
The information that I had, there was two accidents, as well as behavior exhibited coming from the car into the apartment. I believe that that person suffered an injury. That's why I called for fire and EMS as well.
Thank you.
I have a question about that. We've heard testimony about fire and EMS. Did you do that before making entry into the residence?
Yes, Your Honor.
And when I say do that, I should be clear for the record. Did you call fire and EMS prior to making entry into the residence?
Yes, Your Honor. When fire got to the scene, they were the ones that helped us get through the fence to eventually get to the residence. The ambulance was staged in the parking lot, which is just outside of his bedroom window.
Okay, thank you. Any questions, follow up to mine? Mr. Casassa, do you have any follow-up questions based on my inquiry? All right.
So, sir, when you call EMS, that's routine if there's a crash.
It's generally not routine. If there's no injuries, then no, we don't call for EMS.
You didn't know there was any injuries. You were just speculating, correct?
Exactly. That emphasizes my point that I believe there's an injury. That's why I call for EMS as fire as well.
You told us why you think there's an injury based on what you said. Miss Ashby told you.
Correct.
And there was damage to a vehicle.
Yes, 2 crashes was the information that I have.
Okay, but you didn't see 2 crashes.
I don't happen to see a crash. We dispatched 2 crashes.
Well, ultimately, the accident report only reflects 1 crash, correct?
That's the post incident.
Yes, sir.
A report post incident does not have to deal with my agency.
I'm not asking you that. I'm saying the accident report only reflects 1 accident.
Again, I wasn't the reviewing supervisor for the accident.
So you don't know. Nothing for the judge.
Is Sergeant Cohen released? Mr. Casassa, you agree?
I would judge.
All right, thank you, Sergeant. You're free to go. Have a great day. Thank you. All right, Ms. Santini? All right, Mr. Casassa, any witnesses for you?
Yes, sir. I want to call John Heisler.
Okay.
I also want to introduce positive exhibit 6 and exhibit 1. In the evidence.
Your Honor, I'm sorry to interrupt. Can we release Sergeant Kuchon as well? I don't have.
Sure. That's somebody outside?
Can I have one more, Judge?
Yeah. Hold on one sec. Mr. Casassa is going to see if he needs this person.
Yeah, Judge, Miss Kirchhoff, we released, but I'm obviously not releasing this.
Okay, but everyone else in the hallway is free to go.
That's fine.
All right, so go ahead, Miss Santini. We'll wait for you to come back.
Okay.
You can go tell him. Yeah.
So I was entering these in evidence.
Let her release her witnesses, and then we'll pick up there with the exhibits.
She ran away. Just,
Okay. Let's wait for her to come back.
yes, sir.
Thank you. Oh, yeah.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
All right, so before you begin that, Mr. Casassa, you were in the process of offering exhibits into evidence.
Yes, sir. Positive exhibit 6 and exhibit 1.
Any objection? All right, so are these listed as defense exhibits? Defense composite exhibit 6 and defense exhibit number 1, which is Ms. Whalen's statement. Do you need these for your direct?
I might, Judge.
Okay.
May I proceed?
Yes, sir. Go ahead.
Could you state your name for the court, please?
John D. Heisler.
And Mr. Heisler, what's your occupation?
On the present investigator.
Okay. Tell me about your background. You used to be in law enforcement?
27 and a half years with the sheriff's office, 2.5 with the state attorney's office, 17 and a half.
Did you start out on road patrol?
I sure did.
Were you trained in accident investigations?
Back then, yes.
You've seen cars that were damaged, and you can pretty much give your opinion as to whether or not something is severe, minor, or moderate damage.
Yeah, you're at the scene.
Judge, may I have exhibit 6? I'm going to share what's been marked as, I'm sorry. Defense positive exhibit 6. Would you please take a look at this picture, sir?
As to relevance, the objection is overruled.
Based on the crush factor of the modern day vehicles, not something else you can worry about.
So you find that to be a minor accident?
Minor, yeah.
Now, Mr. Heisler, there was a witness that testified, was here previously, Ashley Whalen. Did you see Ms. Whalen down here? Had you spoken to Ms. Whalen previously at my request? Okay, you actually tracked her down, correct? Okay, as a matter of fact, you spoke to her about the incident you were here for today, correct? Okay, would you tell the court what Ms. Whalen said with regard to whether or not there was an injury in this case? Regarding Mr. Giroux?
Sorry?
Regarding my client, Mr. Giroux?
We spoke for 10 to 15 minutes, went through what she saw, and I asked her if she thought he was injured, and she said no. And I said, well, did you tell law enforcement that he was injured? And she said, no, why would I? Because he wasn't injured.
Did she express an opinion that he might be intoxicated?
She did.
I have no further questions, Judge.
Any cross? And is he released?
I would ask you to be released, Judge.
Do you agree? All right, you're free to go. Thank you, sir. Can I have that? Thank you. All right, Mr. Casassa, any other witnesses for you?
No, sir.
Ms. Santini, any rebuttal witnesses? I think you've released everybody, so you're done as well, right? Okay, are you ready to proceed with argument? All right, go ahead. I found, just before you begin, these were on my desk. They haven't been a part of the hearing. Do you want these back?
Well, Judge, actually, I did refer to one of the depositions when I was cross-examining.
Right.
That's why I gave those.
Okay, well, I'll hand those back to you. Just, I know that they're not in evidence and I don't need them. Okay, argument. Ms. Santini, go ahead.
Medical emergency is an exigency exception to the Fourth Amendment search seizure rules for the United States Constitution, and Florida has adopted that as well. And we have in North Florida State, which is 351 Southern Second, 716.
Hold on a second. Say that site again. 351.
351 Southern Second, 716.
Okay.
Bring your copy.
I'm sorry, I did not bring a copy.
I don't have a copy either, but I have a citation. Okay.
What do you expect to happen?
Well, she can still make her argument. You
I
just,
understand, Judge.
go ahead. 351 Southern Second, 716.
And that states that an emergency exception permits police to enter and investigate private premises to preserve life, right, or first aid, provided they do not enter with an accompanying intent to arrest or search. And also United States case in CV, Arizona, 427 US 385, also states the same opinion.
Give me the citation again, please.
437 US 385.
Okay.
And I'm sorry, next time I'll bring a copy of the.
You should actually always bring two copies, one for me and one for the defense attorney. Okay.
And then we have next, the reasonableness of an entry by the police upon private property is measured by the totality of existing circumstances. And that is from Seago State, Borough to Southern Second, Grayson County. And that is a standard that I have found, as well as a search based on theory of medical emergency. It does not require certainty. Fourth Amendment protects against unreasonable searches, and that requires only that the police reasonably believe that an emergency exists. And that's
stumbled as he walked outside of his vehicle, struggled out the front door. And they also knew the correct house that the defendant entered based on actually Wayland walking them to the door and showing them that was where he entered the house. And as we heard from testimony, law enforcement did believe, based on the totality of circumstances, that they had reason to believe that there was possibly a medical emergency for the defendant. And as a result, they started knocking on the doors, the windows, loudly, announcing their presence loudly, several times, no response, and no one was inside. And as we heard from testimony, that also increased the concern to get more into the belief that there is a medical emergency. And as we heard from Sergeant Cohen, that it wasn't the intent to arrest the defendant upon entering the house or the residence. And so as of that, Your Honor, the state just asked this court to deny the motion to suppress.
Okay, thank you, Ms. Santini. Mr. Casassa.
Thank you, Judge. I've got two cases for you. I've provided them to the state.
Thank you.
Judge, I think we'll all agree that there are certain exceptions to the warrant requirement of entering a residence. And the purpose of the need for a warrant and the narrowly defined exceptions is because of the importance of the Fourth Amendment. I would submit to the court that when the state tells you that they may have had, circumstances may have existed that led to an exercise, that's not the standard. One of the cases that I've underlined on the third page on Wheeler versus State, which is cited at 956 on the second 517. It's a second DCA case in 2007. But it's an objectively reasonable basis to believe that exigency existed. I would submit to the court that there was an accident. You have pictures of Mr. Giroux's car. Mr. Giroux was clearly intoxicated, according to Ms. Whalen. Ms. Whalen never said that he was injured. And when asked, did you tell him he was injured? She goes, why would I tell him he was injured when he wasn't injured? He was intoxicated. I submit to the court that she never mentioned injured anyone. She's the only one that saw Mr. Giroux. She told Ashby he was drunk or intoxicated, not injured. Ashby may have said something to Cohen that indicated he was injured, but that's not what she testified in deposition. She said, no, I didn't say injured, I said stumbling. So I would submit to the court that the entry into that house was a pretext because they wanted to get to Mr. Giroux. There's no objective basis to believe that he was injured. When you're having the exceptions to the warrant requirement, there's no DUI exception, Judge. There's no accident exception, and there's no intoxication exception. So what we have is a minor accident that led to an obviously intoxicated man stumbling home, and because of that, knocking on the door because he didn't want to be found, they breached the fence, they breached the sliding glass door to go find him. I would submit to the court, exigency has not been objectively established by reasonable basis. Judge, the Wheeler State case was a battery complaint. There was no evidence of an injured person at the scene. Police knocked on the door. The defendant, Mr. Wheeler, opened the door, and then when asked a question, he backed up into the door, closed the door, and they made entry into the house. And the basis they used were one or two exceptions, but one of them was that someone may be injured. The court said after the initial court ruling, the appellate court said that is not a reasonably objective basis to believe that someone was injured. That was not an exigency. The other case I've given you, Judge, is Reed versus State, 994 Southern Second, 1054 for PCA case 2006. There was a tip about drugs in a motel room. The deputy knocked on the motel room door. A woman opens the door. Mr. Reed was laying on a bed. He called out, Mr. Reed. Mr. Reed didn't move. He said that that was his exigency to believe that that individual was incapacitated or hurt. The courts didn't agree with that and said that is not an exigency. So you need a reasonably objective basis, not just a bear may be injured. And I would submit to the court the motion should be granted.
Okay. Thank you, Ms. Santini. Anything further from you? Okay.
I understand that defense counsel is arguing about whether the witness has stated, Mrs. Whalen has stated there was an injury or not. I would argue that even if there is a discrepancy in the report statement, that officers did believe she said that, and that it may not have been the report statement. However, the state would argue that there are still enough factors that have been observed by Ms. Whalen and then relayed to law enforcement to lead the law enforcement to reasonably believe that night that there was possibly a medical emergency with the defendant. That's all I have on that.
All right, Mr. Casas, I gave her 2 opportunities. Anything else you want to say by way of argument?
Judge, I just asked the court to produce those cases. They basically say they're narrowly defined exceptions, and the exceptions are very strict, and I would submit to the court the fact that he may have been injured, and there's no evidence of that, that's not a basis to enter.
All right, and I have read the cases that you have provided to me, Mr. Casas. I've also pulled up some cases online. Of course, I took the cites from Ms. Santini, and one of the cases I'm looking at here is Fultz, State versus Fultz, 189 Southern 3rd, 155. This is from the 2nd DCA 2016, and they talk about the medical emergency exception. And in this case, it's the officers, the facts in this case, this opinion ultimately found that they did not have the right to enter the residence. The basis for entering the residence in this case, the officers opened the door, and the mail in the foyer, there was mail on the ground, and they had suspicions of an active meth lab, led them to believe that someone inside was experiencing a medical emergency. And this court found that's not enough. Mail in the foyer and a suspicion of drug activity inside is not sufficient. But I don't really point out this case for the facts of it, but they cite to several other cases, one of which is State versus Shillingford, 136 Southern 3rd, 1242 from the 5th DCA 2014, holding that exigent circumstances did exist when the officers were summoned to investigate a battery. They arrived and they saw a blood trail leading to the apartment and heard moaning coming from within the apartment. I know that's not factually on point here, but they were summoned to investigate a crime, and there was some evidence of that crime, i.e. the blood trail leading to the apartment and the moaning. That's different than what we've got here, but it's analogous. What we've got here is we've got the eyewitness, Miss Whalen, who not only called law enforcement officers, but followed the defendant before then. And what she did say, and I believe this is in your exhibit 1, Mr. Casassa, she testified today, and it's in her statement that she was almost T-boned. And so we've got information here. Not only was he involved in 2 crashes, but the officers were also advised that he almost caused the 3rd and almost T-boned Miss Whalen. And so they were, Sergeant Cohen was under the impression, he had the information that there were 2 accidents, one of which includes a tree. I've got this exhibit 6 here that does show a car with front end damage by a tree. The hood is out of place on that car. That was information that Sergeant Cohen had. He also had information regarding that front end damage. He qualified it as significant. I know that Mr. Casassa's witness described it as minor, so there's clearly a difference of opinion, but Sergeant Cohen described it as significant front end damage. The eyewitness who followed him after his erratic driving pattern also described difficulty walking and difficulty opening the door. Now, she attributed that to intoxication, and there's some dispute today about whether she ever relayed her concern or even had a concern that he was injured. Perhaps she didn't, but she did relay that he had difficulty walking, he had difficulty opening the door. So there was some corroborating evidence there based on her observations of his physical appearance and the front end damage to the car that is in fact parked under a tree, that corroborates their information that there was 2 separate accidents. And then we had 2 witnesses today testify that they knocked and announced loudly multiple times, not only on the door, but also on the windows, and got no response. Yes, that's different than the moaning in the Shillingford case, which was one of the grounds to find exigent circumstances. But the absence of any response shortly after he entered, coupled with all of the indicators I've previously articulated, did provide the officers with exigent circumstances and a justifiable basis to enter the residence. And so the motion is denied. Now, do we have another hearing date? Are we set for pretrial? So we can do this tomorrow for pretrial, or we can set it for 2/17.
I would ask for 17, Judge. I have to obviously consult Mr. Jerome, he resides in
2/17, 9 o'clock pretrial. Anything further to come before the court? All right, we're adjourned. Thank you, folks.